proceed?
We are ready to proceed.
Okay, good morning, everybody. This is a code enforcement hearing for the City of North Miami. Today is March 2nd, 2023, and I'm Jose Smith, your special magistrate for the City of North Miami. The special magistrate is empowered under the laws of the state of Florida and the North Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property, as observed and cited by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, so therefore all persons who are speaking should do so one at a time to ensure that all of the testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case, and we will provide you with a translator who will assist you during these proceedings. When your case is called, the property owner, agent for the property owner, and any witness that you may have should announce your presence. When asked, please speak directly into the microphone and say out loud your name, your business and mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney or an affidavit authorizing you to proceed on behalf of the owner. For new cases, you will be asked for the record if you're aware of the violation and understand what it's about. And then I will ask you if you understand it, and you will be asked to resolve the violation accordingly. The city will present its case first, and then the property owner, violator, will be given an opportunity to testify on their own behalf, to bring forward any witnesses and documents, present photographs, and also you have the right to cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city codes exists or existed at the property, then depending upon the type of case, I will set a compliance date or an abatement date for the violation to be resolved. And for repeat violations, I will impose a daily fine amount. For new and non-repeat cases, my order will also include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing date should the violation not be corrected by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table or I will continue your case proceeding to another hearing date in the future. If you do not agree with my findings of fact or ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the signing or the execution of my administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record of the proceedings. This is also called a transcript. This record includes the testimony and the evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at these proceedings. Pursuant to city codes, if the City of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against your property, then the city will charge additional administrative fees to record and release the lien. So what's next, Madam Clerk?
At this time, if we can go ahead and do the pledge. Oh, yeah. Well, actually, clerk, do you want to do your instructions first, or?
You hear me?
We can hear you now. We just don't see you. Okay.
I can proceed with the instruction first if you like.
For some reason, can't hear you, Peggy.
You guys hear me?
I can hear you now.
And thank you for participating in today's special magistrate hearing. The process by which today's hearing will be conducted. Make sure your device is muted at all time unless you are giving.
It's going in and out for some reason. I can't hear you. But if you want to bring them, you can bring it to me and I'll do it. I can't for whatever reason. Sorry about that.
I'm not sure why though.
It's kind of going in and out. Good morning and thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you're giving testimony on a case. If you're using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you're signed into Zoom, you will receive notification giving you access to audio and video so that you may give your testimony. Please accept that invitation to join the meeting promptly. If you are physically in our office and wish to give testimony, you must sign in with the clerk, await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code office to be provided access to a computer. If you would like to speak on behalf of the case, once the case is called, you should click the raise hand feature to be acknowledged. Before giving testimony on your case, please state your name, property address, and a relationship to the property and wait to be sworn in. If you wish to have an interpreter assist during your case, please indicate that once your case is called. At this time, we'll go ahead and do the pledge. And so if everybody that's given testimony today can enable their video and audio to do the pledge.
God bless you.
And then let me give our North Miami officer. Oh, he's here. Okay. All right, Officer Laguerre, we're ready whenever you are. And if everybody can just unmute themselves.
Good morning. We're going to go with the pledge. I pledge allegiance to the flag of
the United States of America.
And to the republic
for which it stands, one nation,
under God, indivisible, with liberty and justice for all.
Thank you. If the city staff can stay with us to be sworn in. If you're giving testimony on any cases today in your city staff, please prepare to be sworn in. Mark, are you there? Okay. We're ready. We're ready. We're ready. Again.
Okay, now, if you are giving testimony today on the case, please rise and raise your right hand as I issue the oath. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
Thank you, staff. Can I have the interpreters please enable audio and video to be sworn in?
Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skills, and ability? Say, I do.
I do.
Okay.
Magistrate, if I can just check with the clerk to see if her audio is working so we can work on any amendments or deletion. Testing, 1, 2, 1, 2. No. Jose, are you able to help Peggy out with this? I'm not sure what's going on with her audio.
Let me give it a shot.
Thank you. We need the clerk. In the meantime, if you want to bring me the agenda, Peggy, I can, I guess, announce any additions or deletions to the agenda, if there are any.
She's saying there's no deletions.
So if that's the case,
Item number 39 would be first.
Okay.
Because he's our attorney.
Okay. So at this time, Magistrate, we're going to go ahead and proceed with, I guess there's no amendments, additions, or deletions to the agenda. So we're going to go ahead and proceed with item number 39, Scott E. Larson Sr., RCCOR 2022-0003, 2080 South Hibiscus Drive. And this is a first-time case. I'm going to just give access to the meeting to Ethan Wasserman. Mr. Wasserman, if you would join the meeting once.
Yeah, I got it.
Good morning.
Shadow, can you mute, please? Mr. Wasserman, do you have anyone else here with you on this item, or are you presenting?
I think I'm presenting myself. My client may be in attendance, but I think I can handle it for him.
Got it. Thank you.
Okay, are we ready?
You may proceed, Magistrate.
All right, Mr. Wasserman, welcome. Tell us your full name and
Sure.
if you're an attorney, tell us that as well. And who do you represent?
Sure. Mr. Smith, good morning. Good to see you. My name is Ethan Wasserman, for the record. I'm an attorney with Greenberg Traurig, 333 Southeast 2nd Avenue, here on behalf of Scott Larson, the property owner in this case. And I think there are two, I just want to make sure there are two cases on the agenda for him. My understanding is one has been deferred or continued. So I just want to make sure we're presenting this morning on the MAT 2022 ending in 00003. Is that what we're, okay.
Yeah.
There's another case ending in 00556. I just want to make sure that one, I saw an email confirmation from the code officer that was continued, I believe.
That is correct.
All right, so we're dealing with a reoccupancy certificate, is that correct?
That's correct.
You understand, obviously, the nature of the violation, correct?
Yes. Yeah. If it's all right with you, I didn't know if staff was going to make a presentation, but I just want to give a little background on the matter.
Well, before we do that, we will hear from staff. I just wanted you to tell us whether you understood the nature of the violation, and if you have anything to say, we'll wait until the
Sure.
city presents. So, Vanessa Willis, tell us what this is all about.
Good morning, Special Magistrate. I'll be sitting in for Vanessa. Mayor Jean, building official. Good morning, everyone. Good morning, Mr. Wasserman.
Good morning.
As of yesterday, March 1st, 2023, there has been no attempts to apply for the reoccupancy on this property. Property located on 2080 South Hibiscus Drive.
Single family residence?
Yes, a single family residence, correct. So the property was posted on February 16, 2023 at 3:52 p.m. And that's all I have, Mr. Magistrate.
Okay. Have you had a chance to inspect the property?
Well, in terms of we checked our in terms of our system in-house, and we didn't see any application that was filed for the reoccupancy for this case here.
Okay. When was the purchase? When was the property sold?
Property. Let's see. It was documented here. So it says June of 2021 from Gino. Let me spell the last name. Tzozzi and Ashley Kimberlin to Scott E. Larson, Sr. and Mary Larson. No approval certificate of reoccupancy on file.
Okay. All right, Mr. Wasserman, let me hear from you.
Sure. So I was retained this week, so I don't have the full background, but what I can share with you is my client purchased this property, that's correct, in June of 21. The seller was the developer, the original builder of the property, as I understand it. And so the property received its certificate of occupancy, and I have copies of this. I don't know if I have share screen capabilities. The client received the prior owner, the developer, received their CO in May 26, 21. And then prior to closing, the seller of the property communicated with the city, and I have an email thread pre-closing on June 2nd from Vicky Santos, saying that because the property was just fully built and went through a myriad of inspections and just got its CO, that a reoccupancy certificate was not required. So I have that in an email, and I could show you that the specific question was asked pre-closing, do we need a reoccupancy certificate? And the answer from the city was no, because it just went through a massive inspection, right, to get its full CO. Fast forward a few days later, they closed on the property on June 10th. So that's the history here as I have it. I was just provided these documents. So I don't know what the code was in 2021. I know what the code is now, and I understand on single family homes, a reoccupancy certificate would be required. We would ask that the violation be dismissed based on instruction from the city to my client pre-closing. And I'm happy to either share screen or email these records to the city for the file.
What does the record reflect? Can you read it out for the record?
Yeah. So from Amanda Lipsky, this is on June 2nd, to Vicky Santos, copying Zulema Hernandez, and it's related. City of North Miami. The subject line says, "Can you please confirm?" There's an email thread with it, but can you please confirm the North Miami reoccupancy certificate is not needed? And Vicky Santos responded on June 2nd at 3:39 p.m. It is not, since it's a new house and just received their certificate of occupancy.
Was your client buying the property directly from the developer?
Yes. That's my understanding. Let me say that's my understanding. The seller was the original developer. Yes.
Okay. I want to hear from the city attorney. What does the city attorney say?
Good morning, everyone. Assistant City Attorney Verdict Malblanche. The code is clear. And everybody must abide by that. I know that in purchasing a home, there are certain, they look to see if permits are already obtained and if everything is up to par. I think at this point we can give the attorney some time, and they can work with their client on how to obtain all the required permits. But it's not that the instructions were correct. If they purchased the property, then they could have already obtained their certificate of use. But we can't just.
I'm not convinced that the code provision in question contemplates a direct purchase from a developer having just obtained a CO and having had everything inspected. So under these unique circumstances and based on the written representations of the city to the purchaser, I'm going to dismiss the case. Can't hear you, Mr. Wasserman.
Sorry, my dog was barking in the background. I went on mute. I said thank you very much, and we appreciate your time this morning on this matter.
All right, you're welcome.
Mr. Magistrate.
Yes, sir.
So I guess that the email, would he be able to send us a record of that email?
Yes, Mr. Wasserman, we've accepted your representation as a member of the Florida Bar regarding that email that you received. Can you please send that email to the building official whose name is on the screen, hopefully by 5 o'clock today? And
Yes.
if it is as represented, then the case is over. If it's something else comes up, we'll revisit that in the future. But based on the circumstances that you presented, where your purchaser bought directly from a developer who had just received a CO from the city, I cannot envision any interpretation of this code provision to apply to those facts. Okay, so that's my ruling.
Absolutely. Just what's the best email address before I log off?
Mr. Wasserman, he put it in the chat for your reference.
Oh, thank you. I appreciate that.
Thank you. Have a good day.
Take care.
Clerk, are you ready?
Yes, I'm ready. Can you guys hear me?
We can hear you now. Yes.
I'm going to call item number 4. It's Coral Terrace Condominium. Case number DEMHS 2022-00411. And this case was previously found guilty with an abatement date of January 12, 2023. Fine was set at $250 plus $100 cost assessment. And the officer is Shannon Sanders.
Thank you. I have a Farron Abasi here on behalf of this case.
Good morning, everyone.
Good morning. Are you an attorney?
I am.
He's dressed like one.
That's half the job, right?
Yeah.
Is there anyone else here that we should be allowing access, or will you represent?
No, I believe it would be just me. The contractor was possibly going to attend, but I didn't get any confirmation that he would. But I do have some clarification on what's been going on.
All right. Before you tell me about the clarifications, first of all, introduce yourself. Tell us exactly who you represent, and are you aware that there has been a prior adjudication involving the same violation?
Good morning, Special Magistrate. Yes, my name is Farron Abasi. The law firm is Peters & Peters, PA. We are general counsel for the Condominium Association, which is 1560 Coral Terrace Condominium Association. I am aware of this violation, as this is now my third hearing, I believe, on this same issue. The last time I was here, I was provided some compliance information that didn't seem to be correct, but since that time, I've been able to ascertain what exactly has occurred with the permit. The issue here is a failure to pull permit for some work relative to the building in concrete. But I don't know if the city wants to go first or if you want me to continue.
No, I've heard enough. Let me hear from the city.
Shannon Sanders, City of North Miami Co-Compliance Officer. As already stated, this is a case for a report of previous compliance. As of my last reinspection date, the permit had not been submitted to the city or obtained. So I'll let the lawyer and the building official give testimony as to what's going on with this. I had a quick email conversation with the building official yesterday regarding this property. So again, I'll let him give testimony as to what's going on.
No, you have to convince me first that there's a violation. That it hasn't been corrected. So tell me about, show me some photographs. I see that the issue is failing to obtain permits to repair cracks along the walkway and throughout the entire building. So if those conditions are still the same, then I might rule in a different way. But if they've been permitted and fixed and whatever, then I might rule a different way. Show me where we are today.
As of the last reinspection, the permits have not been obtained. As you're looking at the pictures, as the director is showing, that's what the photo, if not the property, looked like the day of the inspection.
Which was when?
I'm showing May 4th, 2022.
So I think these are the original photos, right?
Yes, that's the photos from the initial inspection.
Okay, so what does it look like today?
Do we have the reinspection photos in the file?
It's photos, yes, from the last, as the lawyer already stated, we've come 2 or 3 times already. So there is current photos showing repairs being made on file.
This is what some of the repairs look like, right?
Yes.
And those were done with permits?
No permit has been obtained. They have started to make repairs, but again, no permit has been obtained.
Okay. And so where we are today is that we're still not in compliance, even though there have been some patching up. There is no permit for that work.
That is correct.
Okay, now I'm going to turn to counsel for the Condominium Association and ask for the clarification that you wanted to make earlier.
Yes, Special Magistrate. So what had occurred and what I was previously advised was that the permit has been pulled. Much of the work was done and the issue was not pulling the permit. So the last time I was here, I provided the evidence and the information that the permit was being pulled. But when we further dove into the application, it appeared as if the permit that was pulled was relative to a single unit at the association rather than the entire building. The contractor has gone to the city of North Miami and is also dealing with Miami-Dade County. And the permit was in fact pulled as of November 8th, 2022. The reason why it shows up that it's not associated or that there is no permit in existence is because there is no separate folio number that I've been able to find. And there is no separate folio number that the contractor was advised by the city that this permit can be attached to. And they're completely unable to change it to show that they're in compliance as far as the permit's concerned. Last night, I was able to pull the process number and the permit, which the permit description says building commercial repair. It's a typo, but it says repair crash in the hallways, no file created, showing that the permit itself was pulled back in November 8th, 2022. And there's been a couple different actions through, looks like January up till February 23rd, 2023. The last update I have from the property manager is that the contractor and the engineer were advised that there are some revisions that are required for the drawings. But as far as pulling the permit, last time I was here, I thought no permit was pulled after the city clarified that that process number is associated with just a single balcony. Since that time, the contractor has gone back, attempted to change that, has been advised that though the permit is encompassing the entire building, there's no way to change the folio number because no separate folio number exists for the entire structure. I submitted all of this evidence last night as I obtained it, including a list of every single folio number associated with that building, showing that there is no separate folio number for which they can attach this process number to. This is what I'm being advised. This is what I'm being told. And this is what the contractor, Crown Builders, has been doing since around November.
All right, so let me see if I understand what you're saying. This is a condominium association.
Yes.
How many units?
It is a total of around 27 units is what I'm showing here.
Okay, and the 27 units have folio numbers?
Each individual unit has a folio number, yes.
The association itself for the common elements does not have a folio number?
Not that I've been able to find and not that my clients have been told could be attached. So
okay.
No.
And so if I understand you correctly, a building permit was applied for and issued or not issued?
It was issued here. If you pull up this process number, I went on the City of North Miami's website last night and I was able to pull up this information. It reflects as if it's taken out for an individual owner and an individual unit, but that's just not the case.
Okay, so somebody just issued the process number, not the building permit, but the process number was issued under one unit, right?
Yes.
As opposed to the entire building, which doesn't have a folio number. Is that the problem? Is that what you're working with the county on?
That's what the contractor is the county, I believe, is requiring some revisions to the actual engineering drawings because the initial issue was they weren't able to pull permits because the first engineer was just swamped and wouldn't complete the work. upon receipt of this violation and prior to my involvement, they changed engineers. The new engineer was able to submit the drawings. The contractor took the drawings, pulled the permit, and sent me all the information. My understanding was, hey, the permit was pulled. And then at the last hearing, I was advised by Ms. Sanders and Mr. Jean that this permit is only for a single unit, which I then advised my client, who then came back to me and said, this is what North Miami is telling us. Here's our process number. This is all that we have to show that we're doing exactly what we do.
But I don't understand why you're applying for building permits and having plans reviewed in the county as opposed to North Miami.
I believe that they both need to be involved here. I'm not sure exactly why, but this information was previously submitted at the last hearing, and I can share my screen and resubmit it here. But I think let me see here.
All right, I'm gonna put a stop on the bureaucracy issue, and I'm gonna go directly to the work that needs to get done, which are the cracks along the walkways and throughout the entire building. What's the status of the work?
The status of the work, as far as I know from the pictures we have, much of the work was done, and it was just simply the permit issue and the approval. And I have some similar photos that show that the cracks were repaired.
Okay, if you have those, would you provide them to the building official?
And magistrate, while he's showing those pictures, I just want to make it, known. It's not so much as if the work has been done or not. The course here is that no permit has been obtained. I do see the permit number that he's showing that's been on file, and that shows for a crack in the hallway. It's severe cracks throughout the entire building, and again, base short. There's no permit that has been obtained for the cracks.
Yeah, I understand what you're saying, but he's saying that because of the way this association was set up, the condo association cannot get a building permit because they don't have a folio number. So the permit that was issued for a unit. Arbitrarily, somebody chose a folio number that corresponds to one unit, but the condo association is telling me now that everything's been fixed. So I'm going to ask the building official to weigh in on this, because this is right up his alley, But all I want to know is whether number one, what do you do when you don't have a folio number for property? Number two, if you can't get a building permit because you don't have a folio number, what do you do? And then number three, has the work been done? So, Mr. Building Official, bring some clarity to this.
Okay. Good morning again. Good morning, Attorney. I was there at the property around 5 p.m. yesterday, so I could walk through, the entire property. So as I'm seeing here, the permit application BBC 002022 it's basically an application stage. Is not issued. So there's no permit that was issued regarding any repair to cracks in the hallways. So I did observe the cracks. Actually, I did observe the repaired the cracks, and I saw that there were some some AC units, some wall AC units that had the plumbing that was embedded in the top portion of the concrete walkway. So the issue that I have is, although a repair was done, but whether it was done correctly, per code and per some structural engineer recommendation. Also, I observed another new issue regarding the decorative concrete wall paneling. It seemed to be loose. And also, I observed on the west side of the property a clean out that's been uncovered and is draining into the side lawn area to the.
All right, that'll be an issue for another day. But dealing with First, the bureaucratic issue, can they get a building permit without a folio number?
We can, because usually with condo association, there should be one reference folio number, and also the address would tie it to the building itself. So usually, in addition, if we want to isolate further for a condo unit, we'll put unit number 1A or so.
Okay, so if the contractor went to the city today to get a building permit for the entire structure, he or she could do it?
Yes, correct. And it will be tied under the address.
Okay, so council, then you know that the folio number issue is not a problem. You can still get a building permit.
And so the reason I bring up the folio number issue is because last time when I was here, I advised that a permit was pulled, and then I was told by the building officials that this permit is not relative to the reason that we're here for today. And so I've been seeking further clarification from the property manager, my client, and the contractor, and this is what I'm being told. And what I included was the printout of this process number showing that actions were taken by the city January 24th, where it says plans signed in, then plans routed to certificate of use, then routed to zoning, routed to flood, routed to building, routed to structural, provide special form for concrete, provide structural calculation. There's comments here, and they've been trying to get the work done. I'm not here to dispute that they didn't pull the permit back when this existed, but whatever they need to do, I just need someone to tell me, because every time I go to them and tell them what to do, they come back to me and say, well, the city of North Miami is telling me that this is what it is and this is what we need to do.
Apparently, there are too many cooks in the kitchen, because all one needs to do, all the general contractor needs to do is go to the building official and say, here's my application for the entire building, not just one unit. And this is all the stuff that I need to do, and then do it.
So since the last hearing, that is what I understand has been done. And the engineering drawings that have been submitted with the permit reflect that it's work to the entire building and not an individual unit. And I've submitted all this evidence prior to the last two hearings, or at least prior to the first hearing, and I can resubmit the engineering drawings for this hearing as well.
Special Magistrate, I wanted to add also, Officer Perez put it in the chat. There's a reference a folio number that exists is 062229 102 0001, and this could be found on the Miami-Dade Property Appraiser website. When you click the property, it would demarcate the entire property as that reference folio number. Also, the application permit application has denied comments as of February 13, 2023, stating to provide a special inspection form for concrete and provides structural calculations. So there is denial comments currently on the permit application.
The permit application for the entire structure.
Yes, for that, addressing that. Although there's a typo, but I'm assuming there's repair cracks in the hallways.
So that's this process number. Should they my client, when the contractor went to the city in person and was advised there's no folio number, they can't change the folio number, this process number is sufficient to evidence compliance, work under this process number. If you can advise me under what mechanism or how I can change this to reflect that it's under that folio number, I'm happy to tell them to do that. But they're trying to do the work, they're trying to comply, but they're getting differing information every single time.
So the issue is, you have to obtain the permit before, you guys can, complete the, whatever necessary work. So the issue is, what I can do for future meetings when the contractor come in, we could set aside a meeting to have you on the phone or in person. So that way the information would be conveyed to all parties involved.
Whatever needs to be done, because they've been attempting to comply since November of 2022, and if you pull up the process number, that's clear.
All right, here's what I'm going to do. I think that the property owner, although mistaken on his assumptions, because it's very, clearly you go into the Miami-Dade County website and you can find any folio number on any property in Dade County, and the contractor should know better. You have a contractor. You've already engaged the contractor. You have an engineer. You've got all the design professionals. You're just waiting for the to find out what the mechanism is to get a building permit, right?
Yeah, they're applying. They have applied, and they're going in. My understanding is the permit is denied due to these comments, but this also evidences that they are attempting to comply and they are doing what is being asked of them. I'm happy to give this folio number to them. I was unable to find it when I searched under Coral Terrace. My understanding probably is that there's no property address. The owner says reference only, and there's no mailing address. So other than putting 1560 Coral Terrace condo in the subdivision name portion, this would be unable to be found.
All right. Well, somehow Officer Perez has found it, so maybe he can share that information with the building official. Since I had found the property owner guilty back in October of 22, and I gave you until January 12th of this year to comply, which is relatively recent. So what I'm going to do is I'm going to table this for 30 days until my next calendar. And if you have not gone to the building official, which he has graciously offered to do, in many cities, the building officials will not even answer the phone. I can tell you from personal experience that this building official does answer the phone and does meet with property owners. So you have your contractor go out there next week and resolve these issues, because in 30 days, if we're in the same place, I am going to assess the fines, and it's going to be based on the fine that I said. It's going to be a pretty hefty amount. So I'm going to table this for 30 days for you to work it out with a building official.
Mr. Jean, I appreciate that. I will send you an email, and then however you can break this down. My understanding is the contractor is not the best, is not the most technologically savvy. But
that's what I figured.
Anything I can do to help push this along, because they are trying to comply, but there's obviously a lot of cooks in the kitchen. There's certain things lost in translation, and I want to come back next time with this being put to bed. Mr.
Building Official, when you were out there, did you get any life safety issues?
No, there weren't any life safety issues, but there were just items that need to be addressed immediately. I wouldn't say a life safety issue, but
okay. And those new items that you said you observed as a matter of my ruling today, I'd like the property owner to start addressing those before they come to me. Also.
Okay. And also, Special Magistrate, I'm going to put together a letter, so hopefully I can send it out later today to the attorney and the property owner to basically list all issues that were observed as of yesterday.
Wonderful. I'm so happy that you're doing that. With that, you better, Mr. Abbasi?
Yes, Mr. Abbasi.
I would suggest that you, based on what you told me about the general contractor and his or her abilities, I would suggest that you quarterback this whole thing and make sure that it gets done within 30 days.
Sounds good, Special Magistrate. If I have to go myself, I will.
Yeah. I'm not asking you to fix anything. I'm just,
they wouldn't want me to fix it.
No, I just want to make sure that the right people know what they have to do and they do it right away.
Absolutely. Okay. Thank you.
All right. Next case.
The next case is item number 5 and 6. 800 Omega LLC. Item number 5, case number is CEFOB 2022-00140. And item number 6, case number is CEZCU 2022-00286.
All right.
And the officer is Jonathan Lemestre.
Yeah. Let me hear number 5 first, which is the need for a business tax receipt. Is the property owner present?
No, sir.
Yes,
there's no
we
one
have,
Go ahead, Peggy.
we do have Dina Escarment.
Okay. And just for reference, Magistrate, if we can, we're going to go ahead and close number 6 for compliance. They have obtained their certificate of use.
Oh, that makes number 1 easier. Okay. All right. So we're only going to hear the business tax receipt. Anybody representing the owner?
I have Dina Escarment here. Dina, if you can allow or accept access into the meeting.
Saying Zoom is unable to detect the camera. I'm not sure what's going on. Make sure they're not. Are you guys able to hear me?
We can.
But it's saying, I know, but it's saying Zoom is unable to detect the camera. I'm not sure why. Let me try to get on through my phone camera, because my laptop is I'm not sure why it's not.
Are you the business owner?
Yes.
Okay. What I would say, Magistrate, is if it's okay, can we just table the item for 30 days and Dina just give you 30 days to try to come into compliance, reference your BTR, since you were just issued the CU?
Sure, that would be all right with me. It seems like having received the certificate of use, the business tax receipt, it should be very easy to resolve. Although I'm not showing a Dina Escarment as an owner, I just want to make sure that I'm showing an Isaac Escarment as the owner of the property, and that an extension was previously granted.
That's my brother.
Okay. Are you representing your brother?
No, we're both co-owners.
Okay. All right. So you have authority to tell me that you will work with the city and get a business tax receipt within the next 30 days, right?
Yes, sir.
Actually, Magistrate, if we can, I'm just noticing that this is the first time on this matter, and it has been open since March of last year. Though there is compliance with the CU, I would rather that we not table and that we would just do the adjudication and give her 30 days on the issue.
Okay.
So, I mean, we're at a year at this point.
Yeah, and also I noted in the file that an extension was granted to the property owner back in November of 22. So it's been probably a half a year since there's no compliance. So based on the testimony of the city's code compliance officer and the evidence presented depicting that the violation exists, that proper notice has been given, I find in favor of the city and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Thank you.
Okay.
All right, thank you.
Mm-hmm.
All right, I'm going to proceed with item number 7 through 12. It's item number 7, AHDS Ocean King, LLC. Case number is CEFLR 2022000389. Item number 8, case number is CEMHS 2021000107. This case was previously found guilty with an abatement date of April 8, 2022. Fine was set at $500 plus $100 cost assessment. Item number 9, case number is CEMHS 2021000108. This case was previously found guilty with an abatement date of April 8, 2022. Fine was set at $500 plus $100 cost assessment. Item number 10, Case number is CEWAL 2021-0001. This case was previously found guilty with an abatement date of April 8, 2022. Fine set at $500 plus $100 cost assessment. Item number 11. Case number is CEZCU 2021-00211. This case was previously found guilty with an abatement date of October 7th, 2022. Fine set at $250 plus $100 cost assessment. And item number 12, case number is FYBRR 2020-0076. This case was previously found guilty with an abatement date of November 14th, 2021. And fine was set at $1,000. And all those cases are for AHDS Ocean King LLC. And the officers on these cases are Christopher Colton and Gary Beswick, which Mark Jean will be representing that case.
I have an Eric Martinez here on behalf of this property. Eric Martinez, I'm attempting to give you access to the meeting. Are you there? Eric Martinez, are you there?
Yes, I'm here.
Okay, I've sent you a couple invites to join the meeting. Can you accept it so we can hear your cases?
Join as panelists or stay as attendee? Just join as panelists. Okay. They should be in.
Can you enable your video, please?
Here we go.
All right, Mr. Martinez, welcome. State your full name again for the record. And who are you here on behalf of?
Eric Martinez, contractor on behalf of AHDS Ocean King for the violations that were just read. And I thought I was here only for one of the violations.
Do we have the property owner here?
Property owner, no. I had submitted an extension just a little late, and it didn't make it to all the parties to be able to get removed off the hearing today. Regardless, though, I do want to give some good news. I've been working really hard and diligently on all the permits that are needed for clearing these violations. And I was actually up late with a chief building official, Mayor Jean, working on those. And we have a set appointment for tomorrow, Friday at 1:30. He's reviewed all of our permits, and I should have a permit in hand tomorrow at 1:30.
He hasn't reviewed permits because permits haven't been issued. He's reviewed your plans.
That's right.
Okay. Let's take one step at a time. Let's go one case at a time because we have a whole bunch of them, and we want to make sure that the record is clear as to what my findings are as to each one. The first one is a lack of a business tax receipt. What's up with that?
Well, again, Magistrate, he's the contractor, so I'm not sure. Are you willing to accept his testimony on behalf of?
Let me ask you this, sir. Has and you're under oath, has the owner of the property given you authority?
Oh, we didn't swear him in. I'm sorry.
Yeah, has the owner of the property, swear him in first.
Eric, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay. First of all, I want to tell you that if a property owner faced the possibility of being fined thousands and thousands of dollars here, because there's like 4 or 5 different cases here, I would be present. I would not treat this as a willy-nilly, like it's just a nothing situation. So I'm disappointed that the owner didn't seem, or at least a representative of the owner, other than you, was not here.
That's not true, Mr. Magistrate. The owner, I submitted those extensions, and I told the owner the extensions were approved. because I had a verbal approval. The thing was that it did not completely go through, and the owner is now on a flight to see a sick relative to Spain. So I couldn't even get a hold of them since last night.
Who told you that the extension was approved?
I was communicating with the chief building official in regards to getting the extensions approved, but we were too late. I was too late when I submitted them to be able to get them to code compliance so they can do their whatever they do in the inside to remove it from the agenda.
Okay. Do you have anything in writing that authorizes you to be here speaking on behalf of the property owner on all these violations?
I do from previous hearings. I've been on every hearing before that, and I have a power of attorney, but they're limited to that specific hearing. I did not have one for this hearing today.
Okay, but it's the same issues as before.
Yes, there was actually, I believe, 2 more code violation numbers I heard, but I couldn't write them down. But I thought there was only 4 that were supposed to be noticed to appear. That's what the owner sent me. But I heard more numbers. So
yeah, there's 6 of them. What is this a condo or privately owned?
It's a privately owned low-income rental housing.
What's the owner's name?
Louis Bentoncourt. And there's a few owners in that Sunbiz, but that's the person I work with directly.
All right, I'm gonna hear that. I'm gonna hear the case based on your representation that you had a previous power of attorney as to this property from directly from the owner, Mr. Betancourt, you said?
Bentoncourt.
Okay. All right. Do you know anything about the business tax receipt issue?
I do. I submitted for the business tax receipt. We paid the fee, but due to the violations, it cannot get issued, and the violations are directly tied to a permit that I'm trying to clear or obtain with the city to commence renovations of the exterior of the building, and that is the permit that I was referencing. The plans.
All right. Let me hear from the city on number 7, business tax receipt.
That's me. Good morning, Officer Coastal City of North Miami Code Compliance. CEFLR 2022-00389. This violation was issued 6/30/2022. And as of the reinspection date, the violation still remains. I was told because of some of the violations that are still outstanding of other stuff that's the hold up for the business tax receipt. So that's everything I have on that. But other than that, that's the hold up, that they have to comply with everything else.
Yeah, I'm going to adjudicate this case based on the fact that there is no business tax receipt.
That's fine.
What they need to do or not do is in regards to this violation is irrelevant. So
yeah, we're seeking adjudication, Your Honor.
Yeah, that's what I'm going to do based on the unrebutted testimony of the city's code compliance officer and the evidence presented reflecting that the violation for lack of a business tax receipt still exists. Proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So that's my ruling on number 7. Let's go to number 8. Minimum housing inspection. Who's gonna present for the city? Mr. Colson?
Okay, I'll present for the city.
Number 8.
Gotcha. Number 8, CEMHS 2021-00107. This case was originally opened on 9/27/21. It was properly mailed and certified. It's been several. We had a couple of different postponements on this case. As you can see, it deals with the balcony structure. We have a previous adjudication on this case too. And I don't know the process. I need the building inspector to come in on this one and say what's the hold up or why we're not getting anything. But it has been no work done as of to this point. And as a final reinspection, there still hasn't been any work done to this day.
All right. To me, that looks like a balcony, right?
Yes, a balcony railings.
And there's cracking and exposed rebar on that balcony?
Yes.
Okay. Are there people living there?
Yes, it is.
Okay. Mr. Building Official, life safety issue or not?
Well, it needs some attention. So yesterday with Mr. Martinez, I reviewed what the engineer is proposing to bring me tomorrow, and I told him it looks good. Please bring it in so that way we can quickly issue a permit. So I'm trying to go that route so that way he can start work right away with the balconies.
All right. How long do you think the repairs? First of all, how long do you think before a permit is issued, and then how long do you think that they need in order to make the final repairs?
Okay. Well, my goal is tomorrow to issue the permit when provided that Mr. Martinez brings in those documents. The work, I don't have a gauge of, the phasing of, because these concrete balconies will be removed entirely, and the sliding glass door would be disabled for the residents not to walk out there. But it's the balconies kind of clad the entire building facade. So I don't know in terms of how long it'll take him to phase it. I'm sure they're probably doing a section at a time and kind of working around the building. So
is it all balconies or just the one we saw on the picture?
No, it will be entire balconies. They're going to convert those to remove the concrete balconies and change them to aluminum railings, which they're going to embed into the balcony slab.
All right. From my layman experience, seeing balcony repairs on the ocean every other day, these things can take as long as 6 months. Am I incorrect?
It all depends on the speed of the contractor. Probably, Mr. Martinez, can you give if you can, Mr. Magistrate, if he could give us a gauge on how long?
Sir, this has been ongoing since April of last year. We're almost a year into this.
It's actually 2021, Magistrate.
2021.
Well, I'm talking about when I found him guilty. Okay. I found him guilty actually in February of 22. I'm sure that it had been ongoing for a year earlier, as staff has said. What's taken so long?
My permit was submitted in December of 2021, and since then that's what we've been working on. We've taken measures where we've closed off certain balconies and made sure that there are no tenants and any balconies that have cracking on the railings, and it's just been a battle with obtaining the permit. But now that I've been in direct contact with the chief building official, he's been, just working late hours, even with us, just to get this thing issued. And that's our goal tomorrow when we meet, to give them the signed originals and take a permit with us in return. And
do you have a general contractor ready to move?
We do. We have a contractor. We have not ordered materials only because of the volatility in the market, and in addition to how long it's been taken to obtain the permit. So once I do have permit in hand, I will order material and begin mobilization. We're setting up scaffolding for this project. It's going to be the safest way to do it in sections as the chief building official explained. And we are on target to start in 3 weeks from now. If we finish a project we're almost wrapping up, and then we can move on to this project. So I've already been praying and planning to start this project in April.
Staff, what is your recommendation? I want to hear from the city regarding any orders that I might enter. I'm very disappointed that we're 1 year into my order, never mind what happened with the city before, and we're still out of compliance.
Magistrate, the city would request that we move the fines, and at the point of compliance, the property owner can exercise their abilities to request mitigation.
Mitigate. Yeah, I cannot in good conscience sit here and condone what has happened over the last 2 years with this type of, kids fall through balconies, elderly people, and you're dealing, you told me earlier, this is a low income housing project. It doesn't have to look this way. If you're an owner, you have a certain responsibility. And the responsibility here was to start working on this 2 years ago. So I am going to, and I'm going to include, and obviously they can't paint the building until the balconies are repaired. So I'm going to assume that number 9 cannot be complied with either, right? Staff?
That is correct.
Obviously, they go together. You got to fix the balconies, and then you got to paint. So, on
Mr. Magistrate, I'm sorry. I have indicated to the Mr. Martinez also to make sure he's going to apply for a paint permit as well. So those could be concurrent in terms of those that application. So he can come in right in, and we'll move that paint permit quickly for him.
Okay,
Mr. Building Official, if you can, and you have the ability to do that, when I submit this permit and it doesn't get reviewed for 7 months, and until I start crying and being the squeaky wheel, that's when this thing's really started to move. Until 7 months later, after that, no one ever even touched and reviewed this plan. I ask with great concern that the owner be at least granted 30 days. We'll be back in 30 days. If there's not a construction crew working on this property, then you can cite them and lien them and do what is necessary to provide pressure for this person. But there's got to be some kind of balance here between obtaining a permit in a timely manner, but at the same time, reviewing a permit in a timely manner as well. No one touched it for almost 8 months. No one even looked at that permit.
First of all, I want to see from the building official whether or not the contractor is accurate in his statement that the application was filed and that nothing happened for 7 months. Can you address that?
Let me take a look. I know that there was a lag, but I in terms of the estimation and time, I would have to take a look.
While he's doing that, is there a permit for paint application on file? Have you submitted? I'm asking the contractor have you submitted for a paint permit?
I did not. That was one of my plan review comments from the chief building official, and I have a paint permit application ready for submittal tomorrow, and that is the whole meeting for tomorrow. I'm going to submit it. He's going to say, okay, and I'm going to walk away with an approved plan and permit to begin work.
Mr. Building Official, I'm not interested so much in the painting permit. I'm more interested in the balconies and the structural components.
Okay, I'm trying to find the Mr. Martinez. Can you give me the permit application number? You have that?
Yes, sir. It's B as in building, B as in building, R as in roof, 2021-00-480.
And I guess I would call to your attention as well, Magistrate. I'm not sure, and I guess, Mark, you can clarify, is the 40-year building recertification, because that's been pending since 2020.
Yeah, so we're going to hear that. We're going to hear that in a minute.
Does that tie into? Okay.
Yeah, we're going to hear that in a minute. That's a separate issue and one that I feel pretty strongly about.
So the in December 1st, 2021, there was a denial comment. So there's been several denial throughout the initial intake, and also I believe this went to Mr. Martinez. Did it go to Miami-Dade Fire as well?
It's been approved through Miami-Dade Fire, and the comment you're referring to had to do with job value. It's just a clerk. It wasn't a plans reviewer.
Okay.
And that was corrected 14 days later. If you look at every time that you guys give me comments, I return those comments within a matter of 2 or 3 weeks minimum or maximum. We respond really quick because we want to start the job.
So Mr. Magistrate, with railings as well, because it's a life safety item, he had to go through Miami-Dade Fire as well to just make sure the balcony is in compliance with any Miami-Dade life safety issues too. So it seemed to be that there was a lag, but it looks like there's been activity on it, but in addition, he had to go through the Miami-Dade.
I understand that. So that you say that there's a 7-month period where the city did nothing. That's probably because you needed to go to Miami-Dade Fire to get them to agree to the plans, right?
No.
So, Mr. Magistrate, also to add, so there was a flood. The flood had approved December 13, 2021, and then zoning did a denial comment of June. Is it June? Yeah, June 19, 2022. So there was a jump, a lag time between those two actions there. So it didn't move quickly. I can, from what I see here, it was a lag.
It's moving quickly now, and I think that's the big point. It is now, since you're involved, Mr. Building Official, and I thank you. I don't want to be here anymore. I just want to get the job done.
All right. So a lot of these issues could have been heard or were considered by me when I entered an order back in February of 22. That's more than a year ago. So if my order is going to mean anything, and I set a compliance date of April 22, we're almost a year there. If my orders are going to mean anything, I'm going to have to hold the owner accountable. So, you can always go to the city manager or the finance director and get these fines mitigated. But I am going to stand strong in sending a message that orders mean something, and that a lot of these, excuse me, sir, I'm speaking. And so, whatever the reason, you could have come to the city 6 months ago or a year ago and said, look, I'm the deadline is coming. Please give me a continuance, help me out, work it out with a building official. we'll try to do something to protect the residents, whatever. But where we are now, on this matter, my ruling is going to be to ratify the fines. And then, after that order is entered, you can go visit the city manager and plead, mercy and ask that he or she, whoever it is, waive the fines, reduce the fines. There's a process for that. But my ruling is going to be that based on what I've heard, not just today, but back when I first heard it, and the evidence presented shows that the property has been out of compliance since April 8th, 2022. So I'm going to ratify the fines that have been accrued to date in the appropriate amount and assess costs in favor of the city. The fine shall continue to run on a daily basis until there is compliance. So I want to state it clearly that the fines will accrue beginning today. I'm not going to go back to April. I'm not going to hit you with fines going back to April 18th. That would be too harsh. But beginning today, the fines are running at $500 per day. So if you can fix them, if you can do it in a month, you may have a few $1,000s to mitigate, and it will encourage the owner to move along a little quicker. So that's my ruling.
Mr. Smith, may I have one more a word in regards to this? And I wrote this down. Mr. Colson and Chief Building Official, and I have several emails and several scheduled visits to the building department throughout that 7 months where I was not even being heard, where I started going just up the ladder and in the hierarchy instead of just going straight to the chief, because it seemed like such a simple matter. It's just someone to review. And I have evidence of all those things. And had I known that this is how was going to turn out today, I would have submitted that as my evidence. But Mr. Colson and Mr. Chief Building Official can tell you I communicate. I text, I call, I voicemail, I do everything. I show up when they tell me to show up. I cancel appointments to attend to this matter. So it is an important matter, not only to myself and to the residents and for the owner. It is something that that we have been working very diligently, and we do not mean it in any disrespect to your authority to disobey your request. It has been a lot of red tape involved and just getting there. I asked it if you're going to ratify the fines, have the penalty something much lower, because there's no guarantee that these fines will be negotiated. And being that it is not a luxury condo unit, there's not a whole lot of income they're generating from this unit to begin with, and we don't want to take away from the repair or the maintenance to the building. And they do care about maintaining this building, but we can't do anything without permits, because all it does is cause more violations. And that has been, and you'll see the consistent, when we read the rest of the violations, it's all tied back to this permit we're talking about now. And it's going to be a heavy hit as far as doing all these repairs. And it's estimated value at $280,000. And that's where we're at today. So I just ask that you have just a smidge more mercy on this, and I'll be back next month to show you for good faith what we're capable of together as a team, owner and contractor.
Here's a problem that I have with your comment. Number one, even if you get a permit next week, this work is not going to get done for another 6 months. And that's far too long for a property owner, regardless of who was responsible for what or who was responsive or not responsive. You know, I entered an adjudication and I meant it. And so if you were having trouble communicating with anyone in the city after I rendered my order, you know, I understand that, but there was an order entered and it wasn't complied with. And so you're telling me that it's the city's fault because they were not responding. That's not what I'm hearing. Mr. Building Official, was there anybody in your department that held up this the issuance of this permit?
Well, the lag, when I mentioned lag in terms of the review turnaround, there was a lag in the review turnaround when I mentioned the lag.
Thank you, sir.
Okay. Okay. Based on what I'm hearing, Madam City Attorney, if I were to rule that the $500 a day fine starts accruing in 60 days automatically, if there is no if the work hasn't been done, is that out of order?
Your Honor, that's within your discretion. In learning new evidence today, if you want to make that ruling, that's really within your discretion.
Okay, so here's a compromise. Even I've ratified the fines. I will ratify the fines, and they will start accruing on a daily basis 60 days from now if there is no CO issued on the work. Ms. Patterson, do you have any objection to that?
I guess the only thing that I can think of logistically would be Peggy, when does the magistrate oversee our next hearing?
May 4th.
Okay. I mean, technically, magistrate, that would be your hearing. I feel like it's probably appropriate in this matter to just hear it. I think it would make most sense based on the ruling, it's kind of one and the same, I think, but for documentation purposes internally for us, just to kind of ensure that we're, logistically able to kind of manage that. It's kind of out of the ordinary. Would you be opposed to us bringing it back because
No, I'm struggling with it because there has been testimony from the chief building official that the city has not moved with all deliberate speed, and I'm persuaded by the contractor's testimony that he's trying very hard, and he's assured us that he's going to get his permit, and he's going to have the contractor repair the balconies and fix the cracks and whatever needs to be done. But
it seems like he's asking for 30 days. So if you're looking at a 60-day window for the fine to run.
No, he said 30 days to get a permit. I said 60 days to finish the job.
Oh, to be completed.
Yes.
Okay.
That was my intent, is to give him 60 days to both get the permit and finish the work. But
is that realistic, Mr. Martinez?
Well, I don't know, I asked the building official, and he said it depends. Yeah. I don't know how many balconies there are, and what's involved.
There's several balconies, on both in the front and in the rear as well. So that there's several balconies throughout the facade of the building.
He has a meeting scheduled for tomorrow, Mark?
Yeah,
with
yes.
you?
With me.
And in terms of, issuing the permit, would the permit be issued tomorrow?
So if he brings those documents, we can issue the permit, because I told him make sure he has everything in hand and also come to ready to pay for the permit. And also,
so Magistrate, my recommendation would be, based on what was being said here on the record today, I would say that we set the case for your next hearing. By then, the permit should have been issued and the construction should have been started. If for whatever reason that hasn't happened, I would say then that we would ratify the fines as effective today. Basically backdate the fines at that time.
Okay, I want everyone to hear that, because we're not waiting forever. And the other request that I would make, and I would make the request in the form of an order, is that the owner of the property be present at the next meeting to tell me under oath that he is coming close to compliance. I think that the owner needs to be here, and I think the owner needs to hear how serious I am looking at this case to make sure that there's full compliance. So I will vacate the order that I previously read out loud, and we're going to rehear this in 30 days. And hopefully by then, the building permit would have been issued, the general contractor would have been engaged, and much of the work undertaken. I'm a realist, and I just don't see how you can do this in less than 6 months. But if there's a significant compliance, we will just keep monitoring the case and see how quickly we can get it done. So, Mr. Martinez, you've I think we've shown you some mercy, and you owe us the city's insistence on getting this done. So I'll see you in 30 days. But I'm not granting any more extensions after this one. Okay. All right. Let's go. All right. Next one. The next one is we're still on the same property.
40-year recertification.
The building painting, we've already gone through that. The 40-year recertification, have you applied for the 40-year recertification?
Yes, sir. We did. We paid the fee. It will not get approved unless repairs are done in the building, and that's all contingent upon us doing the concrete restoration.
But the actual paperwork has already been filed?
That is correct, and I confirmed that with the chief building official last night as well.
Okay, Mr. Building official, there has been the owner has filed for a 40-year recertification, and the only reason or the main reason why it hasn't been granted is because the work needs to get done, correct?
Yes. So they paid back in October 17, 2022. I think it's that the daycare building, item number 12. And because it reflects on the 40 year, reflects repairs are needed. So it's basically the submitted report is still for the design professional is still not in compliance with the 40 year because they reflect that. Also, will reflect a denial as well regarding the 40 year until the work is completed, everything's addressed, and there's going to be another report mentioning that, hopefully that it's structurally and electrically safe.
Okay. We'll address that next time we meet. Okay. Very well. We're done with this case. Let's move on to the next one.
Clerk?
I'm here. All right, so we're going to move with item number 14, Alexis Castillo, case number CERCV 2022-00163, and the officer is Shannon Sanders.
I have an Alex Castillo here, it appears, on behalf of this property. Alex Castillo, are you there? Okay.
There he is.
Magistrate and Director Patterson, if I can, I'm going to ask that this case be tabled. I received an email from Community Planning and Development stating that the application has been submitted and that it's in process. They are 30 days free from getting the approval. So again, I'm going to ask that this be tabled. We could give it 60 days, but they're asking for an extension again because the application is submitted.
Well,
Okay.
I mean, there's no adjudication.
All right. Is it for the cargo trailer and
It's
the
for-
boat, or both?
They had both at one time, but when we inspected the property, they right now only have the boat parked at the property. And from my conversation with the property owner through his son, through translation, I believe the boat is the only one that's going to be parked there.
All right. So the
moving
cargo
forward.
trailer has been removed.
Yes.
Okay. Mr. Castillo, do you understand what the officer just said? I can't hear you. You're muted.
Hi, good morning. Can you hear me now?
Yeah. Have you been sworn?
Yes.
You have to be sworn. Has anybody
Sir,
sworn?
please raise your right hand.
Raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
Yes, I do.
All right, sir. You understand that we're going to postpone your case because you're trying to get a variance for your boat, but you understand that the cargo trailer cannot be placed there, correct?
Is there any way because we took it over to a friend's place, but we can't really afford to keep it somewhere else. Is there any way that we can do another variance form for that?
I can't give you advice. You're going to have to talk to the code department.
And if I can, Magistrate, can we hear the case? I'd like to, I'm not sure, I'm not necessarily in agreement with the officer. I think we need to hear the item and at least have an adjudication on the issue for, just for potential future, matters at the property. I just want to make sure that there's an adjudication on record, even if you're okay with giving additional time for the city to review their request to store the boat. There appears to be more than one issue, or there was more than one issue, and I think we need to definitely have an adjudication on file.
Okay, well, we're going to get an adjudication on the cargo trailer because under the city's zoning code, the assistant city attorney can correct me if I'm wrong. I do not believe that zoning would allow a cargo trailer on a single family home. A boat maybe, based on what the planning department does with the variance, but I'm going to find in favor of the city based on the testimony of the code compliance officer. I have seen the photographs and the evidence presented depicting that the violation as to the cargo trailer is still exists. Proper notice has been given. I find in favor of the city and enter adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. My ruling is only as to the cargo trailer. I am continuing the proceedings as to the boat variance until the Planning and Zoning Board review that application. So that's my ruling. As far as whether or not you can keep that cargo trailer, you better either ask the planning and zoning director, or you can get an opinion from the code officer who's involved in your case. I don't know.
It's currently not there. It hasn't been there in months.
Yeah, well, it was, and that was a violation. So that's why I entered a violation. Since you've already complied with that, and the city code officer can confirm that by visiting the property. If the cargo trailer has been removed, then you'll be deemed in compliance, which means that there will be no fine.
Okay, I really appreciate it.
Okay, all right. Thank you.
You're welcome.
Item number 15, Barton and Gustier USA Inc. Case number is CEFOB 2022-00215. This case was previously found guilty with an abatement date of February 16th, 2023. Fine was set at $500 plus $100 cost assessment. Any officer is Jose Perez.
I have a Salome Kamok, and I apologize if I'm not pronouncing your name properly. Here on behalf of this property. You would enable your audio and video so we can hear your case.
Yes. All right, ma'am, please raise your right hand.
Yes.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Yes, I do.
Ma'am, state your full name and address for the record.
Yes. Salome Komok, the address 12550 Biscayne Boulevard, Suite 900.
What is your relationship to the property?
I'm the operations manager.
Okay. According to Sunbiz, state of Florida, the CEO of the company is Philippe Marion. Is that correct?
So for the Barton and Gustier USA, he's one of the directors. But the company here in the office, the CEO is Carlos Varela.
Who's Mark Oliver?
He's the CFO, the general director of our parent company, Barton and Gustier France.
Okay. I just didn't see your name in any of the paperwork, so I wasn't sure whether or not you were an authorized agent for the property owner.
Okay.
Are you telling me under oath that you have authority to appear on behalf of the owner of the property?
Yes, on behalf of the company.
Okay. So you've been charged, you've been cited for not having a business tax receipt. And you've been found guilty. You were found guilty by me back in December of last year, and given until February 16th to pay to get the receipt. Otherwise, I was going to fine you $500 a day. What's the problem?
Yes, so I noticed there was the business tax receipt renewal missing, and I filed it online.
You applied online?
Yes, I filed the renewal and paid it online. I checked with the agent listed on the notice to appear, and he confirmed he could see it on his end.
Okay, can the city confirm that the business tax receipt has been paid?
Jose Perez, co-compliance manager. As of checking right now, it appears that it is renewed as of today or maybe possibly yesterday. However, as of the final reinspection, it had not been renewed. At this point in time, the city is allowing Your Honor to use discretion whether or not to impose a fine from the time that they were supposed to abide by and the compliance date, which they did not meet.
What does the code say with respect to the appropriate fine for failing to apply for a business tax receipt? Isn't there a set fine set by the code?
It's at your discretion in these hearings.
Okay. Based on the fact that it's taken well over, 6 months, 8 months.
They hadn't had it since 2020.
Since 2020. So they've paid it for both years, 3 years. Okay. Based on that, I am going to impose a $500 fine. Okay.
Is there any way to reduce the fine? Because there was some change in the company, and unfortunately, I was not aware of this renewal pending.
Well, we went through this. We had a hearing back in December about it. I don't know whether or not you attended that hearing, but the fact is that you were on notice by my order, which was signed in December, that you were in violation. And it wasn't until yesterday that you came around and filed for 2 years in a row. So, there was a violation. I could have imposed a much higher fine. So I think a $500 fine right now, based on the circumstances, is appropriate. So that's my ruling.
Thank you.
Mm-hmm.
The one-time fine, clerk, just in case.
One-time fine, yes.
Item number 18, we have Gina A. Vargas, Julieta D. Manette, case number RCCOR 2019-0041. This case was previously found guilty with an abatement date of February 4th, 2021. Fine set at $250 and plus $100 cost assessment. And Gary Beswick is the officer, and Mark Jean would be the person hearing the presenting the case today.
We have a Gian Carlos Moscoso here on behalf of this property.
Did you say Carlos Moscoso?
Gian Carlos, yes.
Giancarlo, okay.
Good morning, everyone.
Sir, please raise your right hand. No one answered. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
Yes, I do.
Is there somebody with another device that's...
Mr. Moscoso, I think that's your TV.
No, that's my wife at work. Let me actually go to another room. Bear with me for 1 second. Apologies. All right.
Sir, please state your full name and address for the record.
My name is Giancarlo Moscoso. The property address is 13560 Northwest 2nd Avenue.
Who is Gina Vargas and Julieta Manet?
Gina Vargas is my wife. Julieta Manet is my mother.
Okay.
I'm a registered owner on the property as well.
Okay. You're being cited for not having an approved reoccupancy certificate. Do you understand the nature of the charge?
I do.
Okay. And what's your explanation for not having one?
Your special magistrate, I actually been in the process of communicating with a new building official, Mr. Jean, regarding this process. Matter of fact, I was able to hire an engineer for a missing piece that I needed to close my permits, which for which I should be getting that final piece by tomorrow or Monday at the latest. However, this week when I approached the city to proactively find out more about my permit and what to do to close my permit in order to file for occupancy certificate inspection again, I came to find out that my permit had already expired. I believe it was in 2021. Although at the time when I actually approached the city in 2021 regarding my open permit, because of the COVID-19 emergency order, I guess for the state, I was told that my permit would be active wouldn't expire within the 6-month period, but it would be active for 3 years. That's the information I was given by the city at that time. So yesterday, the building official explained to me that ordinance was only valid during the emergency ordinance, effective time. But after that time, it was no longer valid. And obviously, I wasn't aware of that. I was just trying to close my permit so I can go ahead and close my case for this hearing. But now I come to find out that I need to reapply for a renewal of that permit so I can close it. And I'm in the process of that, actually. And that was
all right, Mr. Building Official, what's your take on all this?
Hi, good morning again. Good morning, Mr. Moscasco. Mr. Moscasco and I talked yesterday, and I indicated to him that the permit that he has, BBR 00-2020-00395, was expired on October 6, 2021. And that he mentioned to me about the governor's emergency order, the COVID-19 emergency order. And I indicated to him that order has since been, is not in effect now. So he's I indicated to him that he needs to pay for a permit renewal that's in the order of $1,042.17. So once he renews that, he can call for his inspections, and he has, I believe, he's going to get a engineering as-built certification because I believe the work was completed. So with that, he'll be, once the inspections pass and with the letter, we'll be able to close out the...
What was the nature of the work that needed to be completed?
It was it's alteration, renovation of kitchen and bathroom, electrical, a panel, and central AC upgrade, a tank water heater, 9 windows, 3 doors, 9 shutters.
Special Magistrate, if I could add to the building official's comments, those were all renovations done by the previous owner of the property prior, I guess, before I purchased it with my wife and family. And so the permit that we're dealing with is for concealed work, and from which I already passed electrical and mechanical. My only missing portion from the permit was plumbing and building, for which I already have hired an engineer. And I should be getting that result or the results of all the work done by tomorrow or Monday, and that's the reason why I proactively went ahead to the city and
okay. Are you saying that this was pre-existing work that had been done by the prior owner, and you had nothing to do with it?
Correct. When I purchased the property, it was fully renovated, and I didn't find out anything about this until the building official at the time showed up to my house after I purchased the house for the occupancy certificate and told me this wasn't here, you needed a permit for this, you needed a permit for that. I was like, I just purchased the property.
Okay, so you got and Mr. Building Official, correct me if I'm wrong, the work that was done needed a reoccupancy certificate and an after-the-fact building permit.
Correct.
And that's the process that he's in right now. Getting the after-the-fact bit, and then once he gets the after-the-fact building permit, CO or building permit, and then closes that permit, then he's able to apply for his reoccupancy certificate. Is that how it works?
Yeah, correct. Just one thing I need to add. He had the permits for the work, but it expired. So he just needs to come in to file for the renewal. So once he gets that, he can continue with his inspection in order to close that permit, so that way he can move forward with the reoccupancy. Because once he closed that, then the reoccupancy should be approved.
Okay, I'm going to table this for 30 days.
Thank you, your special magistrate. Thank you, building official, Mr. G.
Next case.
Item number 19. Ishelt Valencia. Case number is CERCV 2022-00306. And the officer is Jonathan Lemestre.
I have an Ishelt Valencia here on behalf of this property. If you would accept the invitation to join the meeting, and we'll swear you in. Ishelt Valencia, are you there?
Yes. Hi, good morning. Can you hear me now?
We can hear you.
We can hear you, but we can't see you.
Oh, I don't know. It's let me see if my camera is on. Okay, there we go. Can you see me now?
Yes.
Okay. Hi. Good morning.
Raise your right hand, ma'am.
Let's swear it in.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Okay. State your name, ma'am, for the record.
Yes, my name is Ishelt Valencia. I'm the property owner for 880 Northeast 128th Street in North Miami, Florida. And this is in regards to case number CER.
Yeah, I know the case number. I just need to know whether you're aware of what the violation is about.
Partially. I still need to understand what I need to do because I did send the payments for the permit.
Well, very simply, apparently you have a recreational vehicle on your property. Yes. Okay. And the code says you're not allowed to unless you get a variance. Okay. And the question that I have for you is, what have you done, if anything, to get a variance from the city so that you're able to keep that recreational vehicle on your property?
Yes. In November, I went to the Code Enforcement Department, I believe it's in North Miami City Hall, and I submitted the fee to get a permit. I didn't get any kind of confirmation. They just took the paperwork and they said they were going to contact me, and I didn't get anything after that.
All right. I want to hear from the code officer because it doesn't seem logical that she would write a check and give it to a code officer. And it's more likely that if she wrote a check, she would have given it to the planning folks.
Yes, sir. Good morning, everyone. Code Compliance Officer Jonathan Lemestre, City of North Miami. On October 15th, 2022, I opened a notice of violation in regards to multiple recreational vehicles on the property at 880 Northeast 128th Street. At the time, she did not have a variance on file, but I see on record on January 14th, 2023, she did obtain a variance to have one recreational vehicle on the property. One variance, one recreational vehicle. As of the final reinspection date on February 17th, 2023, I observed 3 recreational vehicles on the property. I did have a conversation with Ms. Valencia, and I informed her that she can't have 3 recreational vehicles on the property. She has one variance, one recreational vehicle. Ms. Valencia informed me that she's attempting to sell 2 of the recreational vehicles. That's why they're still on the property.
Do you have a picture showing the 3 vehicles?
Yes.
And can you show it to me?
So that's back
one.
up. Yes.
That's one. Where are the other 2? That's a different one?
Yes, those are on October 15th. That's when I first opened the case.
Okay. And they all fit on the property? How big a property is it?
It looks pretty bad. I did receive a complaint from a resident in regards to all the vehicles. That's February 17th. That's 2 recreational vehicles in the backyard. And that would be number 7, picture number 7. That would be the 3rd recreational vehicle on the property.
Okay. So she got a variance from which board?
From Community Planning and Development zoning for 1 recreational vehicle.
All right, and let's see. Ms. Valencia, you obviously knew when you were given the variance before the Community Development Board that it was for 1 vehicle, and yet you went ahead and put 2 more.
Can I give you information of the reason why I have 3?
Yes.
RVs. Okay. So I initially wanted only to purchase 1. There's different auction services online. I went online. I see SCA Auctions, if you want to look it up. It's one of the companies that they allow you to become a member and auction. I initially became a member to buy a vehicle, a regular vehicle. But when I saw that they had RVs and I have a family member that wanted to stay in the house, my father, I wanted to buy a recreational vehicle for him so he can stay in the back. During the auctions, they don't tell you right away that you won the bid. And unfortunately, I won for 4 recreational vehicles. And that was unfortunate because it was very costly. And I got very upset. I have emails that I sent to them that they should have updated the website immediately. So I know that I already won 1 bid. I didn't need to buy another vehicle. And immediately they start charging storage fees and transportation fees. So I had to cancel 1, and it was very costly. And I could bring the other 2 and hopefully sell them so I can recover the money that I spent, because it was my inexperience in doing auctions online and not them updating the website created this issue for me. So I only want to keep 1. Now the other 2 were like salvage. They have damages. So in order for me to sell them, I have to I've been replacing the glass windows in one of those, and the other one has hail damages. So I'm finishing with the repairs, and I'm hoping that I can go ahead and sell them quickly. So that's why I wanted to request an extension, but I'm only going to keep 1.
All right.
Magistrate, if I may, I think that we're okay with giving her some time based on what she's explaining. We would like the adjudication, obviously, but I am concerned. I did hear that she made testimony regarding her father possibly living in the back of one of the units. Is someone living in the one that you intend to keep?
If there's 1 person, yes, but it's not fully. You have to do the plumbing and the electrical, so it's just to put the items. At some point, we want to go ahead and do all the installations so he can stay in that trailer. Mm-hmm.
Okay. Well, that in and of itself is another concern. So the city does not permit for occupancy in a recreational vehicle.
Yeah, you understand that, Ms. Valencia, that if you're thinking about having anyone, your father or any guest, living in the recreational vehicle, you're going to get cited again.
But what's the reason? If you can give me some information about the law, because I've seen properties in other locations nearby that have 3 occupied trailers, and they don't seem to have any violations.
Well, if you have information that somebody's violating the code, then you go to code enforcement or you call them and you report them, and the city will follow through. But just because somebody's breaking the law doesn't give you the right to break the law. You're not in a residential single-family neighborhood. You're not supposed to live in a trailer. That's what trailer parks are for. And people don't like living next door to somebody that has a trailer with somebody living in it. It's just not good neighborly practice. So I understand you got a variance, you got the right to have one, And as far as the other two, I am going to find you, I'm going to find that based on what the testimony that I've heard and the evidence presented along with the pictures, I find in favor of the city and enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Let me tell you what that means. If you don't remove those other two trailers, and it doesn't matter whether they're disabled or broken or whatever, you're going to have to find a way to put them somewhere else. They cannot stay in a single family home because you only have a permit for one recreational vehicle, not three. And your concerns about getting ripped off or making a mistake or whatever, you know, I appreciate that, but it has nothing to do with the law in the city of North Miami. So you got to remove them. You got 30 days to remove those other two trailers. Give them away, sell them, do whatever you want, put them in a garage somewhere, but not at your home. You only have a permit to have one. So if there's anything else, let me know.
Can I add something to your comments, please, if I'm allowed? Yes.
Yep.
Realistically, and I would like an extension of more than 30 days. Selling two trailers that still need repairs, and I will sell them as is, might take more than 30 days. I need to also do paperwork and transfer them. Is there a way that I can get 60 days if possible?
All right, we'll do 60 days, but not a day more. Okay.
Okay.
If 60 days, you're not those trailers are not out of there. I'm gonna find you. I'm gonna find you, and it's gonna be a daily fine for every day that they remain there. I know that that's gonna be burdensome, but you cannot have three trailers when you only were given permission for one.
I understand.
Okay?
Now,
so I amend my order to reflect a compliance date of 60 days.
Okay. My question: how do I get a confirmation or a copy of the certificate for the permit that I did receive? Because I only submitted paperwork and payments, but I didn't receive any confirmation or documents.
You would go back to where you did the application, and they should be able to supply you with a copy.
Okay. And if I need to keep you updated during these 60 days that I already have a buyer and he's going to purchase, do I submit that as well?
Stay in contact with your officer. That's who you would need to be in contact with.
Lemastre. Okay.
Once the trailers are gone, you call the code officer, and there'll be another inspection, and they will clear the property from any violation. They will say that your property is in compliance.
Okay. Yes.
Okay. All right.
Thank you.
Good afternoon. Next case.
Item number 20. Which is Gene Roberts, and the officer is Gennaro Murillo. The case number is CEFOB 2022-00261.
Gene Roberts, are you there? Gene Roberts, are you there? Okay, there he goes. All right, we have a Gene Roberts on behalf of this property. Gene, if you would enable your video, please, so that we can swear you in and hear your case. Gene, are you there? I'm not sure where he went. I don't even see him logged in anymore. So I guess we can
He's on the panelist.
You see his name? I don't see his name.
Yeah, he just removed.
Yeah, I don't see his name. Roberts, are you there?
Okay, so the next case.
Okay, yeah, let's move on. We can come back.
The next case is Keystone 2009 LLC. Case number is CEBCM 2021-00004, and the officer is Jose Perez.
This is number 23?
Yes.
Okay.
Danny Monticello, are you here on behalf of this property? Danny, are you here on behalf of this property?
Yes, I am the owner of the property. Good afternoon. My name is Danny Monticelli.
Just a moment, sir. Just a moment.
You got to be sworn in, sir.
Sir, please raise your right hand.
Can you raise your right hand to be sworn in, please?
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
Yes, I do.
Sir, please state your full name and address for the record.
My name is, good afternoon. My name is Danny Monticelli. I am the owner of the property 12855 Hickory Road, North Miami, Florida, 33181.
That's Keystone 2009 LLC?
Keystone 2009 LLC.
All right. You're being cited because your boat is extending into your neighbor's property. Do you understand the nature of the charges?
I understand clearly.
Sir?
I understand clearly.
Okay. So what are you going to do about it?
Since I've been living in the property for 12 years, and the water goes every day 4 to 5 feet. So in the morning, the boat goes to my neighbor. In the afternoon, the boat goes to my house. The picture that is taking right now is a picture at the moment that the boat moved. I tie the boat. I put it back the boat. When they comes, everyone, my neighbor never talked to me about it. Always go to the city. I don't understand what's going on with him. I moved my boat. It's more than 2 years that the boat never moved from the same place. It's not that I go outside and then I come back and put the boat in his side. It's about the water, your magistrate, that the deep that goes the canal in Keystone every day. I will have to be 24 hours on the deck looking to see if it goes 1 feet or if not going 1 feet every day. I try to see what I can do because I put it back. But like I tell you, the problem is the canal, how many feet goes every day up and down. So it's not that every day is 4 feet in his side. Sometimes there is an officer that I've been seeing him for more than 12 years since I am there. And I know that I never had this problem before in the past. This is a new neighbor that came to here, and he has like a fiction with my house.
Well, sir, I'm going to let the code officer explain to me what the nature of the violation is and address the issue of the boat moving one way or the other way. I've never heard of anything like that. My next door neighbor has a boat. My other neighbor has a boat, and they don't move. Once they're moored to the piling, that's it. It doesn't move. It's not like there's a hurricane moving it from one side to the other. I just don't understand the argument. Maybe I'm naive. Maybe I'm not a boater, but I think I have lived on the beach enough, on the ocean, on the bay enough years to know that what you're telling me just doesn't sound right. So let me hear from the officer.
Just before Jose speaks, Magistrate, I just want to grant your permission. I do believe the neighbor is here that filed the complaint, and he has his hand raised. I'm not sure if you would be willing to, if you would like for me to give him access into the meeting, or if you'd like to hear from the neighbor.
I normally don't like to hear from the complainant, and we normally just rely on the code officer. to explain, but certainly the neighbor has a direct impact on what we're trying to do here, and certainly she would be a fact witness that the city may want to put in if it's the city's decision to allow the neighbor to testify on in proving the violation. I have no objection to that. So let me start first with a code officer, and then you can have the neighbor supplement your testimony.
Good morning, Jose Perez, Code Manager for the City of North Miami. We're hearing the case in regards to the property at 12855 Hickory Road. As it relates to this case, it's actually a fairly old case at this point in time. The property owner was issued a courtesy notice way back when, in April of 2021, advising them to kindly move the vessel back. That courtesy notice went ignored. It escalated to a violation in May 15 of 2021, which also went ignored. In essence, the reinspection came and the vessel did not move. As to the testimony that Mr. Danny is giving as it relates to the vessel moving up and back with the tide, that just means he doesn't have a back line securing the vessel more closely to his property. If you secure a line in the rear of the vessel, it cannot move up. It just needs more tension, because if this line is adequately holding the vessel, it just can't move up. It's stayed there, right? So if there's too much slack, then you can move up and down, and that seems to be a problem here. So in addition to that, he does have a boat lift behind this vessel with another vessel on it. So if he cannot secure this vessel to stay within his property lines, it'd be in his best interest to remove the vessel altogether from the back of his property if he cannot retain it there, because per ordinance, it needs to retain within this property lines that are set forth. That's the testimony that I'm giving. I would like to open up the floor to Mr. Michael Garcia, who is the neighbor who is directly affected, being the fact that he has a vessel that he cannot bring to his property because of this circumstance.
All right, before we hear from the neighbor, can you just put up a couple of the photographs that you took of the boat? Okay, so we see what is that called? The stern or the bow?
That is the stern.
That's the stern. Okay, so the stern is and the property line is where
where the plank is on the left-hand side, correct?
The property line, the neighbor's property is on the left side of the photograph, where there seems to be like a wooden structure.
Correct.
Okay, so first of all, he's already encroaching into the setback, correct?
Correct.
And beyond the setback, I assume the setback is at least 5 feet, right?
As it relates to the vessels, they're actually allowed to go from property line to property line. It'd be a setback if you were to install a dock or a piling or a boat lift, but from the vessel itself, it could go from property line to property line.
Okay, there is no setback issue.
Correct.
Okay. So approximately in that photograph, how many feet into the neighbor's property is this? I'm going to call it a yacht. Okay. Looks like a yacht.
Yeah. So I would say roughly 4 or 5 feet, depending on the days. I've gone on multiple days and it has been a little bit more, a little bit less. But for the average, I would say about 4, maybe 5 feet.
Okay. And in your testimony, you said that the line is not properly attached because it doesn't have enough tension on the boat, so it allows the boat to shift one way or the other with the wind.
That is correct. And my expertise from what I've seen and my experience here doing a lot of waterway inspections, you can tension the line enough so it won't move up or down.
Okay. How just curious, how deep is the water there?
It would have to possibly be maybe more than 20 feet, my assumption.
40.
Okay. 40?
40.
All right. Okay, I want to hear from the neighbor. What's,
Mr. Garcia, can you enable your video, please?
Yes, ma'am.
So that we can swear you in. Clerk?
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So
I do.
That, please say I do.
I do.
Okay, Mr. Garcia, you're here as a witness to testify on behalf of the city of North Miami. Do you understand that?
I do.
Okay, and you're the immediate neighbor to the property at 12855 Hickory?
I am.
And do you have a boat also?
I have two. I have three. I only have two here at my residence, sir.
And they all fit within your property line?
Yes. And to further go on what Mr. Perez said, they're all on my property line. They all are within my property line. Okay. And nothing is encroaching.
Do they shift with the wind?
They don't shift with the wind. I've never heard that before, especially when a boat is moored. They don't move. They just move up and down with the tide. They do not move over left or right. But my boats happen to be on both of them are on lifts, so they're not moving at all.
Okay. Mr. Monticelli, how large is your boat, your yacht?
50.
How much?
50.
50 feet?
Yeah.
And what is the width of your lot?
75.
75. So you got plenty of room within 75 feet. You got enough room to put a 50-foot yacht, right?
I have a lift that is taking almost 20 feet in the north side of the property. I can go back with the boat as was for 1 year, and I think so was in the middle of the property at that point when they checked last year.
Well, you're going to have to somehow figure out a way to keep your boat within your property, sir, because if you don't, I'm going to fine you. I know how important waterfront views are, and I know how annoying it is when my neighbor's boat is 5-10 feet into my property. So let's fix that as soon as possible. In the meantime, based on the testimony of the city's code compliance officer and the adjoining neighbor, I've seen photographs and the evidence presented showing that the violation still exists. Proper notice has been given. I find in favor of the city, enter an adjudication, and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. So you got 30 days to figure out what you need to do to keep that boat within your property line. If not, you're going to start accruing fines. And the fines will start accruing in 30 days. So whatever you need to do it sooner.
I will. Thank you very much.
Okay. All right.
Special Magistrate, I'd just like to make a statement. What he stated was completely incorrect, that I've never spoken to him. When I purchased the house, the realtor sent him a certified letter, which I've included as evidence. And I spoke to him when I signed the contract for my boating lifts and asked him kindly to move the boat because I'm going to begin construction for the 2 lifts. At that point, he stopped talking to me. Okay, so I went to Mr. Perez and asked him what I should do. And he says, well, I can go find him. I said, well, I don't want to start a war with my neighbor. And he said he was going to issue him a warning. Okay. To that date, I finally moved into my home and the boat is still there encroaching on my property. I want to see my boats. I don't want to see his boats.
Great. Are you, where is this property, on Keystone?
Yes, sir. Hickory Road.
Okay. Yeah. Okay.
But I did make several notifications to him and spoke to him in person, and he was given a written notification, certified letter sent before I moved in, as soon as I purchased the property.
All right. I believe you, and I have already ruled. I appreciate your getting involved. I had a similar issue with a neighbor of mine. We worked it out peacefully without having to go to court, without having to, basically I gave him permission, and that was the end of it. So
that's all I'm looking for, sir.
Yeah. All right. So thank you all. I'm ready to move on to the next case.
Thank you, sir.
That's it. I've ruled.
I see that Gene Robert is logged back on, so I'm going to go ahead and call Gene Roberts' case, which is CEFOB 2022-00261, and the officer is Gennaro Murillo.
All right, Mr. Roberts, let's try it again. Can you see if you are able to join the meeting, please? Roberts, are you there? There you go. All right, can you enable your video, please? Just need you to unmute yourself now.
All right, ma'am. Yes, we can see you and hear you.
Okay. All right. Good morning.
Please raise your right hand before you proceed.
Yes.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Ma'am, please state your full name and address for the record.
My name is Gene Roberts, and my address is 488 Northeast 137th Street, North Miami, Florida 33161.
Are you the owner of the property at 486, 488 Northeast 137?
Yes.
Okay. Do you understand the nature of the violations that have been cited in your against your property?
Yes, it's stated on I'm in violation of not having a business tax receipt.
Okay. Why haven't you been able to get a business tax receipt?
Okay. Well, when I started my business, I went to the county, a local business tax receipt, because of the of some clients I was pursuing, which is GOV type clients. So I had to get a local business tax receipt. I also went to the city of North Miami, into the clerk's office, which is that office that is across from the utility office. And when I went in, the attendant, when I explained to her what I'm doing, the type of business I do, I sew curtains, right? And I said, all I do is I have a little room in the back and I sew curtains. I don't bring people into my house like clients. And she stated, based on what I described, I do not need to have a local business tax receipt issued from the city of North Miami. This is about 2014, 2015. So fast forward now, there was one time I believe I did attempt when I went in last December to talk with the officials, the folks in the finance department, and explain to them what I just stated. They said, yes, on record, it shows that I did attempt, but I didn't pursue to get a local business tax receipt. And I don't remember what year that was. So from that conversation I had with that lady back then, I never continued to pursue getting a local business tax receipt from the city of North Miami. Now, at that time when I went in, this was December 14, and I stated to them, based on the total calculations that they gave to me of owing $1938.70 plus the $193.20 that I paid on that date, that I'd still had to pay it regardless. And I said, I don't have the funds based on what you're asking. Now, 2 months later, I'm getting notice again to appeal with reference to this. I don't have a problem with having a local business tax receipt, but the burden of having this much money to pay for all those years beyond, I don't have it. When I asked him to print me each of the each year, at the top of this right hand corner, it says payment slip, right? For each of the year reference, and of course the accumulated charges. I went ahead and I said, okay, I'm going to pay the $193.24 for the current year, which is 10/1/2022 through 9/30/2022. The payments, and they wrote at the top right above this barcode 2017-2018. I'm asking for some kind of relief. This is my house. I haven't even paid the mortgage for February 2023. The first time I have not paid the mortgage in over a year because unfortunately funds are dry right now. Not enough payments is coming in from my clients. So I'm like, what am I supposed to do? Don't want to have to know that I have a threat of a daily fine on top of what is supposedly owed versus what I have to committed to pay to make sure I keep this house.
All right. I need you to stop right there. I get it. Okay. Just have a couple of questions. I see two addresses. Is this a duplex?
It's duplex. On the 486, I get guaranteed income from a tenant of $1,250.
Okay.
Of which I do. I don't pay my tithes for.
I don't.
I don't care what. Sorry, go ahead.
And okay, you've answered it. And what you're telling me is that you do window treatments, curtains, that type of business, right? And you do that out of your home.
Yes.
Right?
Yes, I sew in my home, yes.
Okay. So to that extent, you are engaged in a commercial type operation. I'm going to ask the code officer to explain a little bit more about how she is permitted to do a business out of a residential area, number one. Number two, does the fact that she does this window treatment business, is that considered such that you need a business tax receipt or not? And where do we stand today with respect to her ability to get her business tax receipt, and how much is she going to have to pay to get it?
Good afternoon. So all the information about how much she has to pay is with the finance department. The violation was open based on what the finance department advised, which she didn't had paid for all these years after the initial payment on when the application was made on March 2014.
I did not make a payment at that time. All I did was started the application. I never made a payment.
Please don't interrupt. I'll give you all the time in the world, but let me hear from the officer first. So you're back charging her to 2014?
Yes, sir.
How do you know that she started the business in 2014?
Based on an application that she made in the finance department with the business tax receipt. So the finance department retroactively charged her for a business tax receipt from 2014 to 2022 or 23? Yes, sir.
Madam City Attorney, does the statute of limitations apply?
I'm looking to see, but I never came across anything in the code that said that there's a statute of limitation of when the city can start enforcing its code. Law basically says that the city can enforce its code whenever it wants. Now, whether or not he can retroactively charge the resident all the way to 2014, whether or not you're that's in your discretion, Your Honor.
Well,
just for clarity, Magistrate, the case is not, the issue around how much she owes is not a matter that we're concerned with. I think what we're concerned with as it relates to the case is the fact that there is not a current or valid business tax receipt. So in terms of negotiating, what she owes or, arguing, we don't, as it relates to code compliance, we don't don't know, and we don't profess to know. That would have to be something that we can discuss directly with the finance office.
Yeah, I understand that we're here today on one business tax receipt that she's required to have in order to operate her. By the way, can she operate a business out of a residential property?
Yeah, she can.
Okay. So the question is, ma'am, we're not going to get into all the years that that were mentioned. We're not going to go back to 2014. The issue is, why haven't you paid for a business tax receipt for the current year?
I hope you can see this, but this is a receipt that I received when I went in on December 14, 2022, and I paid $193.25. I stated to them, I want to use this fund to pay for the current year starting October 1st, 2022 through 9/30/2022. However, on this paper, when I paid the $193.25, he wrote on there for 2017 through 2018. So therefore, in my attempt to pay it, it's like I'll have to keep paying until when they decide, okay, I've complied, I've paid all the penalties associated with it. Then they will issue me the certificate, the tax receipt.
It sounds like, magistrate, that there's a what I'm gathering from the situation is that she was perhaps misadvised at some point regarding the license and whether or not she needed to have a license, thus did not come in for any renewals. And at some point or another, I'm not sure what led her back to the city to pay the license after having been advised that she didn't need the license. Nonetheless, I can see it appears to me that in good faith she's come in to try to obtain. I think I would have one question. Did anyone that you spoke with whoever advised you that you didn't need a license here at the city, do you have something in writing, or was that just a verbal conversation?
It was a verbal conversation back then, in 2013 or 2014, 2015. It was a verbal conversation I had.
And then what led you to the city to make the payment in 22?
Yeah, well, I would change the question. Why did you ask in 2014 whether or not you needed a permit?
Because at the time I was pursuing some GOV contracting opportunities, and one of them said I had to make sure I had a business tax certificate from the city and the county. The county I have, but when I went to the city, I started the application process and then I canceled it. I stopped pursuing the application. So I left it there, given the fact that my prior visit to the clerk's office stated that I did not have to have the business tax receipt in order to do what I do.
And what made you circle back in 22?
Well, I received one of these notices on my door. One of these notices on my door that I need to appear to a special hearing, notice of hearing. That's when I had to go into the office and say, look, I don't want to have a fine on my house, issued per day. So I asked them to print off of what they're saying that I owed. And I said, I can only pay this $193.25 at least for the current year.
And what did they say to that?
Still gave me this tabulated calculator sheet. I don't know if you can see it, showing that I still got to pay the $1,900 remaining balance. And I'm like, I don't know what to tell you because I don't have the funds.
Did you ask for a 2023 license permit? Business tax receipt?
Yeah, I did ask for it. I did ask for the 2022, 2023, and they stated I could not get that until I paid all the prior years first. That has been past due.
Right. So the city would not give you a permit for the current year unless you paid for the prior years. Is that correct?
Yes.
All right.
I guess they would be gauging that, magistrate, based on, corporate records and, when the business was incorporated and active dates. And I'm guessing.
Yeah. I'm going to table this, and I'm going to ask the city attorney and the finance department and the code officer to work this out, because in all good conscience, I don't see how the city gets around the statute of limitations, and I don't want to advocate for the property owner, but I think that this needs to be worked out in a manner that is fair and legal. And I don't know that the city can go back to 2014, 15, 16, 17 and collect for those years. That's just too far back. And there's testimony that she was told that she wouldn't have to pay for it. It's questionable in my mind if you're a tailor and you're doing some, window treatments, whatever, it's questionable whether that even meets the definition of a business. I'm a lawyer. I do work out of my house. Is my house a law office for which I require a building, a business tax receipt? No, it's ridiculous. If you're a doctor and you're talking to patients on the phone at your home, does that make you a business? No. So I think this. I'm sorry. I think we need to get everybody on the same page as to what is legitimately owed, and get this lady some relief, because I empathize with her. She wants to do the right thing, but she's running into concrete blocks, and I think that we need to work with her. So I'm going to table this for 30 days and see if you guys can work out the issue of back payments and get her. If Ms. Roberts, I don't know if we have her contact information. Do we have her information, Gennaro? If not, Ms. Roberts, did we lose her?
I'm still here. It's just that my connection is bad. I have to get rid of this phone.
Ma'am,
do you mind putting your contact information in the chat?
Yes, I will.
Your email and your telephone number, please, and I'll personally circle back with you.
Yeah, I don't feel comfortable telling this property owner that she needs to pay $1,900 for a business tax receipt to do part-time window treatment at her duplex. I just don't feel right about that. So let's see if we can work this out. Ma'am, are you understanding what I'm saying? Ms. Roberts? Ms. Roberts, are you there? Can't hear you.
Yes, I can hear you. Yes.
Okay.
Yes.
I'm going to put off this case for 30 days and ask that the city, that you get in touch with the city. Ms. Patterson, are you going to get involved, or is someone else?
I'm happy to help. If she can provide us with her contact information, and we'll grab the information. Someone can just send it to me, please. And I'll circle back and I'll try to bridge a conversation with her and the finance director. Okay, because
I've worked with enough finance directors in my career to know that many of them, not all, not even most, but many of them, all they want to do is collect the money for the city. That's why they're there. They want to collect money. But I think that there's some limitations that apply, and the city attorney may want to look into the statute of limitations applicable to collection of debts, and how many years back the city can go. Even the tax collector, when they go back, when people, for whatever reason, they don't, they declare homestead, but they're not homestead. They do a reinspection. They find out the property is being used for commercial purposes, so they eliminate the homestead. There's only so many years that they can go back and try to collect for due payments. There's a, I think it's 4 or 5 years, I think maximum. Anyway, I don't want to preach anymore on this. I'm ready to move on. We'll hear this case in 30 days.
Jean, just provide your contact information in the chat. Oh, she already did. If we can just grab that, please. Thank you. We'll table it for 30 days.
Okay, thank you.
Thank you very much.
All right. Magistrates, there's no more cases for any attendees currently. We do have.
We don't have anyone else here on behalf of. Actually, there's who's 305-940-2159. Hi, what case are you here on behalf of? 2159 telephone number. And I also have a R. Waxman, Peggy.
We heard that case already.
Okay.
That was the first one.
So we're gonna assume that that we don't have any additional panelists. I guess we can at this time excuse the interpreters if that's okay.
That's okay.
Yes.
All right. Would you like to take a 5-minute recess, Magistrate, before everything else is done?
I would love to. I just want to figure out what time it is.
Any idea how many cases left, Clerk?
We should be finished hopefully by 1 o'clock, you think?
I have 23. I think I have 23, if I'm counting correctly.
23 cases?
Left. But none of them are represented, so it should go through. We should be able to get through them fairly quickly.
Okay. All right. I got another appointment at 1:30, so hopefully we can get out by 1:30. Let's take a 5-minute recess.
All right. Thank you.
Okay.
Recording stopped. Oh, sorry.
Mr. Waxman? Mr. Waxman, you're saying your item was number 38?
That's what was showing up.
What's the property address?
1329. Well, the case involved 13250 Biscayne Bay Terrace.
Okay, so we'll hear your case next. I apologize. There appears to have been some confusion.
Okay, the case actually involves a Ricardo Costa.
Are you the property owner or are you the neighbor?
No, I am the neighbor.
Okay. Okay, so it's not your case. It's the case against your neighbor.
That's correct.
Okay, so the cases will be heard. The property owner didn't show up on behalf of the item. We're still going to hear the case. So you could just stand by if you want to hear the outcome of the matter once it's heard.
Well, can I ask you this? Do I have any involvement at this point? I mean, you all have got everything. And by the way, nothing has been done. I mean, I just left the property.
Right, we're aware. That's why the case is on the agenda. We'll present the item and there will be a ruling. I would, if you're interested in standing by just to hear that ruling, that should happen in a couple minutes.
Okay, thank you.
Sure thing.
Am I doing valet?
right. Are we back?
Recording in progress.
Yes, we are back. And Peggy, if we could go ahead and just hear 38.
Is the property owner present on 38?
No. So at this time, Magistrate, all of the items that are going to be heard are not represented by the property owner. No one showed up on behalf of any of these properties.
Who's presenting?
Item number 30.
Who's presenting
I'm
on
going to call it
38?
into record. Item number 38, Ricardo and L. Lewis Costa, case number CELSC 2023-0011. The officer is Jose Perez.
Mr. Perez?
Good afternoon. Jose Perez, co-compliance manager for the city of North Miami.
Yeah, let me just try to save you a little time. I've reviewed the file. I've looked at your pictures. I don't understand what the triangle ordinance requires. I saw a drawing. I saw the fact that the owner tried to trim some hedges. It looks better now than it used to. I know that it has to do with traffic safety. So just explain to me what is the nature of the violation.
Well, the pictures that the property owner submitted are for the wrong property. That's not the property in question. The property in question is the one that I submitted. So the latest picture was off February 16th. As you can see, the hedges are really high up. So they pretty much cause a line of sight issue for the neighboring properties to exit their driveway. So with that hedge planted this way, unfortunately, you cannot see, and it causes a hazard for a vehicle to possibly hit you as you're backing out of your driveway. That is the issue, and that is the violation in question.
Okay, there were other pictures with a very low hedge, and it was not exactly perpendicular.
Correct. That is not the property in question. I'm not sure why the property owner uploaded that picture. It is not the same property.
All right. Do you have that? Okay. So is that property in compliance?
That property would be in compliance. Correct.
So that's the way it's supposed to be.
Correct.
Okay, because I thought that was pretty nice, but then you're telling me that it's the wrong property. Okay, now I understand. And the purpose of the ordinance is so that motorists will be able to see and pedestrians will be able to see when they cross the street, and it doesn't create a safety hazard. Why do they call it a triangle?
That's just the way the ordinance was written. The arborist would have to go into detail as it relates to that. But in essence, it just means that the section there has to be within that restraint of, I believe it's 4 feet or something. So it's the little tiny section between the driveway and the street view. And this is the letter from the city's arborist that she's provided saying that they are in violation.
Okay. Isn't that the swale?
That is correct, yes.
And it's the city's property anyway, right?
That is correct. However, the property owner planted this. The city did not plant this.
Yeah, but theoretically, the city could say to the property owner, "Get rid of all this," or take it down yourself, for that matter.
Well, technically, they could also apply for a permit, but they would have to reduce the height of it to from what she states, and I believe what the code requires, 2.5 feet.
Okay, so what's the problem here? That the owner just won't comply, or what's the issue?
So at first, the property owner got in hold of the arborist, and they were working. However, from what the arborist explained to the city or to our department, they stopped working with the arborist. So at this point in time, no process has been made. So we don't want to remove the hedges. We want the property owner to keep their hedges. We just want them to comply and successfully reduce the height of the hedges and properly obtain the permits to have the hedges there.
Okay, when were they cited?
The violation was opened back in February of 2023. They were given a reinspection date of February 3rd, 2023.
All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter adjudication and set a compliance date of, let's say have to go through permitting, I'll say 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. And I'm setting the fine at $500 because this could potentially be an accident waiting to happen with traffic in Miami the way it is. So,
just for consideration, Magistrate, Jose said February. I think this kind of our arborist notified us back in January 3rd to be exact, that it appears as though that they had been in contact with the property owner. So based on the fact that it is a public safety hazard, would you consider reducing the turnaround to 30 days? They had been in contact with the city. They've since not.
How long does it take to get a landscaping permit?
I mean, it appears as though the arborist was fully engaged until the property owner stopped engaging. So by now they would have had it had they continued the process. So, given consideration to that, would you reconsider in reducing that?
Yeah. If the process is already ongoing and it's just a matter of, getting the permit and getting a landscaper, it shouldn't take more than 30 days. So let's amend the order to provide for a compliance date of 30 days. The $500 a day fine thereafter remains.
Just for a record, there's also the neighbor here on the call that's listening. He's sending messages in the chat. Would you, I know you've already given your ruling. He's asking, can he speak in the chat?
Yeah, I'll permit it.
Okay. Mr. Waxman, you can join the meeting.
If it's okay with the city, I'll permit it. City, are you okay with the witness testifying?
Sure.
Okay. Mr. Waxman, please, first of all, I'm going to need you to be sworn, and then I'm going to ask you for your name, address, and your relationship to the property in question.
Your Honor, can I say something, please?
Do you solemnly swear? Do you solemnly swear or affirm this? Go ahead.
Yes, I do.
Madam City Attorney, what is your question?
No, I was just going to say, I'm not sure if the property owner is present so that he or she can have an opportunity to cross.
Well, the property owner chose not to attend, so the witness is testifying as a fact witness on behalf of the city of North Miami. Okay. I've already entered my ruling, but I want to give the neighbor the opportunity to say his piece and get anything off his chest that he would like, but I've already ruled. Mr. Waxman, you want to say something?
Yeah, what I wanted to say was the last place I wanted to be was here. I have tried every which way to settle this neighbor to neighbor. I've lived in my house for 28 years. Whenever there's been an issue between neighbors on our street, and we're on a 1-block street where I'm at, everybody knows each other. We all deal with each other cordially. This is a matter of safety. This is absolutely a matter of safety. You cannot see when you pull out of my driveway. you cannot see the street. The potential for being T-boned by a car coming down the street is huge. And I'm surprised we haven't had an accident. I have two 20-something daughters living in my house right now. I would love to think that they're always careful when they're pulling out. But I don't want to have that on my conscience afterwards. And my neighbor he refuses. You know, he's a hothead. He absolutely refuses to engage in any constructive discussion. I sent the picture that apparently confused you. Okay, that's a property at 1830 Alamanda Drive in Keystone that is in perfect compliance. If my neighbor brought his hedge down to that 2.5 feet level, there would be no issue.
Yeah, I appreciate everything you've said, and I agree with you. I'm very sensitive to the safety issue. Whether you're 26 or 56 or 76, it is a safety issue. I have heard of this triangle ordinance in other cities, and I wasn't 100% sure what that meant. But now that I saw the pictures that you submitted, which normally I don't look at pictures of other properties, but I was under the impression that apparently there had been compliance because the pictures that you submitted looked fine to me.
I apologize for confusing the issue.
Okay, but they were part of the agenda, so I reviewed it, and so I now understand the issue well. I do consider this to be a life safety issue. It is an accident waiting to happen, and that's why I've reduced the time within which to comply to 30 days, and I am going a little bit above what I've been fining people today. I've gone up to $500 a day for noncompliance, and absent that, you may need to if they still don't comply, you may need to have a conversation with the higher ups in the city and maybe have the city go out there and remove it at the owner's expense. That would be the next step if there's no compliance. Okay?
Thank you, sir.
All right.
Thank you,
You're
sir.
welcome. Have a great day.
You too.
Okay, let's go.
Item number 12297 Northwest 7th Ave, LLC. Case number CEGMP 20220091. And the officer is Jonathan Lemestre.
Officer, please proceed.
Good afternoon, Special Magistrate. This case is in regard to a parking lot in disrepair. The address is 12297 Northwest 7th Avenue. The parking lot, the violation was opened back on May 23rd, 2022. In regard to potholes, cracks, parking stops are missing. The parking lines are in disrepair. The violation was opened back on May 23rd, 2022. As of the final reinspection date, compliance has not been met.
I have reviewed the pictures. I find the parking lot deplorable. I can't believe that people do that. Is it a commercial property, residential? What is it?
It's a commercial property. The check cashing store is leasing the property from 12297 Northwest 7th Ave, LLC.
Okay. And this was open last year?
Yes, sir. May 23rd, 2022.
What took so long to get it to me?
I don't have an answer to that, sir.
Okay. It's just a rhetorical question.
No. I mean, it's but yeah, I think. But Jonathan, we gave them an extension internally a couple times, and I personally spoke with. I think Jonathan's been in contact with the property manager. And I've personally spoken with her as well. I think that there's been a change, perhaps, like if I can recall correctly, a change of ownership and some things like that. We did grant them some extensions. It appears as though that there's still not been any movement. So we brought the case, and we wanted to go ahead and move forward with the adjudication request.
Okay.
But they have been engaged.
All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented showing that the cited violations still exist, proper notice has been given. I find in favor of the city and enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 2.
What does? What? Never mind. Go ahead.
Item number 2, 12350 Northeast 6th Ave LLC, case number CEBPR 2021-00107, and the officer is Shanna Sanders.
Ms. Sanders?
Shanna Sanders, City of North Miami Co-Compliance Officer. This is a case that was already adjudicated. I'm showing here, I believe it's September 22nd, 2020.
The case number 2 has not been previously adjudicated.
Found guilty on, I'm showing the notes here. I apologize. This is a case. The notes I'm showing here was adjudicated, found guilty on November 18th of 2020.
What property address are you talking about?
Are we on 12350 Northeast 6th Avenue?
The agenda is not showing me that it has been previously adjudicated. Maybe it was, but it's not showing on my agenda packet.
I'm going to apologize, Magistrate, but I'm not sure, and I'll be honest enough to say this is a case that was passed on to me as past Officer Aaron Barber retired. I'm only going by the notes here. I was handling her previously adjudicated cases. So again, from the notes that I have here, I'm showing, and I don't know if that's from a repeat violator case or just whatnot, but I'm showing it was adjudicated November 18th.
Okay, it does show that this is a repeat violator with violations. I've made some notes when I went through the file. Apparently, they had been cited previously in 2021 and 2022, which makes it a repeat violator. But there has not been, as far as I can tell here, there has not been a previous adjudication. It's not noted as an adjudication. Let me put it that way. So I'm dealing with this case, which may be different from the prior one.
Well, let's hear it as a new case. Let me we'll hear it as a new case.
Is it about offense after the fact?
I'm showing here after the fact fence. I'm showing the notations here. I'm showing it as a repeat violator case under case CEBPR 2021-00091.
Yes, that I know. They've been previous. They have been bad boys earlier. I know that.
Yes. Mm-hmm.
Okay.
So just for clarification purposes, the case has been to magistrate a couple of times, and all those times it was been tabled. There is no adjudication on it yet.
And who's speaking?
That's our
St. Louis.
Oh, okay. There you are.
Okay. So again, a new case that we're hearing for a building without permit. We're hearing it as a repeat violator under the case already stated CEBPR 2021-00091. That was adjudicated 12/20/20 of 21. It was found guilty. As of my last reinspection on February 16th, compliance had not been met. I have spoke with the property owner who later submitted an application to the city. It was submitted February 22nd to obtain a permit for the fence. But again, as of the reinspection date, compliance had not been met.
Okay, based on the unrebutted testimony of the city's code compliance officer and the evidence and photographs presented depicting that the cited violation still exists. And by the way, I've looked at the photographs in the file, especially the one of the fence. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Next.
Item number 3, 13100 Sunrise Plaza, LLC, DEFLR 2022-00318. Any officer is Tamara Petit.
Good afternoon, Officer Petit with City of North Miami Code Compliance. On August 29th of 2022, it was found that Nicole's Fashion Inc. did not have a business tax receipt. And as of the reinspection of February 16th of 2023, they were still not in compliance.
Okay. Any contact with the owners?
No, sir.
You've left them the notice. You've mailed the notice to the right party, correct?
Yes, sir.
All right. I noticed that you sent it to the registered agent, Richard Wolf, and that you posted. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation still exists, proper notice has been given. Find in favor of the city, enter an adjudication, and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Next.
Item number 13, Alan Levine, case number CEGMP 2022-00083. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine set at $250 plus $100 cost assessment. And the officer is Tamara Petit.
Good afternoon, Officer Petit with North Miami Code Compliance. This violation was first seen April 8, 2022. During the reinspection, they still were not in compliance.
When was the reinspection?
The reinspection was February 17, 2023.
So no change since last year?
No, sir.
Okay. Keep going. It still needs a paint job?
Yes.
Okay. Based on the testimony of the city's code compliance officer, the photographs and other evidence presented that the property has been out of compliance since October 20th, which is when I heard it. They had to abate by December 2nd. They have failed to do that. I find in favor of the city and hereby ratify the fines accrued to date and assess costs in favor of the city. The fines were set at $250 plus $100 cost assessment. So whatever that comes out to, that's the fine. And the fine shall continue to run on a daily basis until there is compliance, and the city is authorized to file the appropriate paperwork and liens necessary to secure payment.
Thank you.
Item number 16, Farida Property 1 LLC, case number FYBRR 20200002. This case was previously found guilty with an abatement date of January 14th, 2021. Fine set at $500. The officer is Gary Beswick. This case will be heard by Mark Jean.
Mr. Building Official, we can't hear you.
I'm mute. Sorry. What case number?
16.
The 2020-0002. Carry that property. 1 LLC. Case number 16.
76.
40-year recertification.
So it was posted February 7th, 2023 at 1:36 p.m. And it showed here, I have here, report received August 9th, 2022. So it seemed that, and is abated by January 14, 2022. So let's see. I have a notation here for. It seemed like it was complied with. Sorry, I'm just kind of scrambling with the notes here.
So, Mark, just for reference, this one is 12500 Northeast 4th Avenue. It's reference a 40-year building recertification. It looks like they were found guilty and they were required to abate by January 14th, 2021. It appears as though they remain out of compliance unless there's something that you have to.
I have a note here that says report received August 9th, 2022. So it indicated something was received.
You want to table the item?
Yeah, the
so
table. Yeah.
I'll table it, but if with these 40-year recertification cases, and I don't know what kind of property it is or what kind of deficiencies they might have, structural or otherwise, I don't like to take these casually. Like sometimes you have to get their attention. Have you visited the property, Mr. Building Official? Are you familiar with it?
I have not. But I can do a visit. I can do a visit for this property.
All right. So here's what we're going to do. I'll table it for 30 days with the understanding that the building official will go out and check the property. And if he finds any life safety issues, to take whatever appropriate action may be deemed necessary in accordance with his authority as the city's building official, up to, issuing a notice to vacate if he finds serious issues. So I don't want these 40-year recertifications to turn into a nightmare one day. So please keep your eye on this property. We'll talk about it in 30 days. Hopefully the owner will have the courtesy to show up and tell us where he is with respect to the 40-year recertification. Just filing the report is not the end of the story. The report may have conditions and limitations and find that there are violations that need to be addressed. So just filing the report, in my opinion, is not sufficient. There has to be compliance with any requirement that the report brings to our attention. Anyway, you understand that, right, Mr. Building Official?
Yes,
Mr. John?
correct.
Okay.
Thank you.
All right. You have a lot of authority to act on these matters, including sending the owner to the Board of Rules and Appeals, and even then revoking their, demolition, if you will. You have a lot of authority. Please exercise it wisely.
Thank you.
Mm-hmm. Okay, next.
Item number 17, Gautier Jean Marie Emile Paolini. Case number CEBPR 2022-00459. And the officer is Jose Perez.
Mr. Perez.
Good afternoon, Jose Perez, Co-Compliance Manager for the City of North Miami. We're hearing the case in regards to the property at 13507 Northeast 23rd Court. This is in regards to a property where construction was done without permits. This case previously got some extensions. However, they have not complied. The property was originally notified of the violation in March 25, 2022. By the reinspection, they had not complied. The property was sent via certified mail on February 2nd, 2023 for this hearing. It was also posted at the property. At this point in time, the city is requesting an adjudication of a daily fine amount for them renovating the interior of the property without any permits.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the property has been out of compliance. Well, that's a ratification. I'm going to start again. Based on what I've heard, the testimony that presented and the pictures depicting that the cited violation exists, the proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Moving right along.
Item number 21, John Mazel and wife Cecilia. Case number CEFOB 2022-00191. And the officer is Jose Perez.
Mr. Perez.
Jose Perez, co-compliance manager for the city of Miami, to hearing the case in regards to property 2235 Magnolia Drive. This is in reference to licensure that has not been obtained. This was previously tabled by the magistrate. The property, in essence, is running a home-based business. They obtained a business tax receipt at one point in time, and they never renewed it. The business is still active according to the business organizations on Sunbiz. So at this point in time, the city is requesting that an adjudication and a daily fine amount is set. The property was sent via certified mail and posted for the hearing on February 2nd, 2023, and no compliance has been met.
This whole thing started April of last year?
I believe so, April 14, 2022.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs, no photographs here, the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 22, JR 129th Street LLC. Case number CEBPR 2022-00408. And the officer is Shannon Sanders.
Shannon Sanders.
About a fence installed without a permit?
That's correct. Shannon Sanders, City of North Miami Code Enforcement Officer, property address 565 Northwest 129th Street, for building without permit for a fence that was installed in the rear of the property. Upon my last reinspection, no permit has been obtained. I am showing proper service was given. I posted the property on February 6th. Certified mailing was also mailed out. I have not had any contact with the property owners or any listed agents regarding this fence. And again, as of the last reinspection date of February 16th, no applications have been submitted and no permit obtained.
Do you know if the property is occupied?
I visited the property on one time and I saw a vehicle in the front along the swell, but no one answered the door. So that was the only contact or visibility that I've seen.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photograph and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 24 through 29. Kissimmee 3205.
Let's read. It's going to take a while to read all of them, huh? Let's do them all. Yeah, well, let's read them all, and then we'll go back and do them one at a time.
No problem. Item number 24 through 29, Kissimmee 3205 Shops LLC. Item number 24, case number CFOB 2021-00045. Item number 25, case number CEFOB 2021-00048. Item number 26, case number CEZCU 2021-00189. Item number 27, case number CEZCU 2021-00192. Item number 28, case number CEZPU 2021-0053. And item number 29, case number CEZPU 2021-0054. Any officers, Jose Perez.
Okay, so
let me see these, just so that I'm clear, we're looking at cases beginning with 24 through 29, right?
Yes.
Correct.
Okay, the first one is business tax receipt.
Correct.
No business tax receipt. Is that right?
That is correct.
And that's, I guess we're dealing with two addresses.
That is correct. Two neighboring properties owned by the same corporation.
Okay, and that's 13025 and 13035. So the first one is 13025 business tax receipt, no business tax receipt. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Let's hear number 25, business tax receipt as to the adjoining property. 13035.
Okay, so 13035, essentially same as the previous case. They were cited back in November 2021. The property owner has not obtained it. They were served via certified mail on February 2nd, 2023 for the hearing, as well as posted at the property. At this point in time, they do not obtain it. So therefore, the city is requesting an adjudication and a daily fine.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists, that proper notice has been given, I find in favor of the city, enter adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. '26 is the property at 13025. Certificate of use.
Item number 26. This relates same as the previous violations. They were cited back in November 2021. The property owner has not obtained it for this hearing. Post property. At this point in time, they have failed to obtain their certificate of usage, and the city is requesting an adjudication as well as a daily fine amount to be set.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists and that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Next.
Number 27, this one relates to property 13035 Emerald Drive. This is for the same reason as the previous, failure to obtain a certificate of usage. They were cited back in November 2021. They were served via certified mail on February 2nd, 2023. It was also posted at the property. At this point in time, they have not obtained their certificate of usage, so the city is requesting an adjudication as well as a daily fine amount.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. The next one is a little different.
Correct. So,
We're going to talk about that because I want to make sure that I understand exactly what the violation is.
No problem. So number 28, as it relates to 13025 Emerald Drive, they were cited for prohibited zone usage, right? So this property was previously residential housing for the university, right? When that university sold and relocated, they sold off their off-house camping, off-campus housing. And at this point in time, the land is not zoned for it to be an apartment complex, a residential property, and as it relates to the rental of the units. So at this point in time, they, in essence, have been operating illegally because it's not zoned for that purpose. So they were originally cited in November 2021. And there are letters in here from the zoning department, from the zoning director, and it advises the properties in question 13025 and 13035 Emerald Drive are zoned public use. This current zoning does not permit residential use. Therefore, the conversion of student housing to a multifamily residential use is not permitted. As such, any operation, a use not permitted within PU district is a violation. With that being said, because they are in violation, the city at this time is requesting a adjudication as well as a daily amount, a fine for a daily amount as it relates to the operation of the apartment complex until they either get the adequate zoning approved or stop using the property as residential multifamily, as indicated by the zoning director.
This is the housing for the students that used to attend the university at 125th Street. What's it called? It's no longer there.
Johnson Wales.
Johnson and Wales. So this was under a zoning that permitted student housing, but not residential. Right? Not residential. And so are there people living there now?
Yes.
Okay. All right. So they would have to rezone, basically.
That is correct.
All right. And that's a fairly lengthy process, but they need to start somewhere. And so what I'm going to do is I'm going to enter identical orders on both 28 and 29, so I don't have to repeat myself. There will be separate orders, but they both will say the same thing. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented, including evidence that the property is being used improperly, it's non-conforming to the zoning, and the proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Now, if the tenants leave, the violation goes away. If the building is demolished, the violation goes away. But what they can't do is they cannot rent these units to the public, to residents who are no longer students at the university.
Correct.
Right. Okay. I got it. Anyway, that's 29, 28 and 29. We don't have a third. 30 is Majestic.
If I may, just really quickly, I'm sorry, I might have missed it. Jose, did you cover the feedback provided by the zoning office regarding this issue? Did we get a response from them? Okay.
Yeah, the zoning doesn't allow it. They need to rezone.
Yeah, okay, because I know that there was an attempt to have it rezoned, and I wasn't sure what the follow-up was on that, and I missed it during the testimony. I was working on something else, so I apologize.
Yeah, it's currently zoned public use, and it needs to be rezoned to residential use.
But I think they went. What was the outcome? Did they follow up with us on what the outcome was?
It has not passed.
So it went before the Board of Adjustments?
Yes.
Okay, and it was declined.
I believe so, yes.
Okay. All right.
Okay.
Item number 30 through 32. No, item number 30 to 31. Majestic Apartments 1 LLC. Case number MHVI 0202200226. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine set at $500 plus $100 cost assessment. And item number 31, case number is MHVI 0202200227. This case was previously found guilty with an abatement date of December 2nd. Fine set at $500 plus $100 cost assessment. And the officer is Jose Perez.
All right, Mr. Perez, you're on.
Jose Perez, co-compliance manager for the city of North Miami, considering the property, the case for the property at 12990 Northeast 6th Avenue. This is in reference to failure to obtain permits for windows that were installed on the second floor. As of my final reinspection, permits have still not been obtained. The property was sent via certified mail on February 2nd, as well as posted at the property on February 2nd, 2023. At this point in time, the city is asking for the fines to be eradicated. And yeah.
All right. So I'm going to ratify the fines based on the testimony of the city's code compliance officer. The evidence that I've reviewed, property has been out of compliance since the abatement date of December 2nd. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 per day. And the fines shall continue to run on a daily basis until there is compliance.
Item number 32. Marquez Property Holdings, LLC, case number CEFLR 2022000235. This case was previously found guilty with an abatement date of February 16, 2023. Fine was set at $500 plus $100 cost assessment, and the officer is Tamara Petit.
Good afternoon, Officer Petit with City of North Miami Code Compliance. The initial violation was found April 25th of 2022. Upon my final reinspection, February 17th of 2023, they were still not in compliance.
This is for business tax receipt violation.
Correct.
Right?
Yes.
Okay. Based on the unrebutted testimony of the city's code enforcement officer, the photographs, no photographs. The evidence presented showing that the property has been out of compliance since the abatement date of February 16, 2023. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 per day and assess costs in favor of the city. All fines shall continue to run on a daily basis until there is compliance.
Item number 33, it's Marquez Property Holdings, LLC, case number CEZCU 2022000469.
Good afternoon, Officer Petit with City of North Miami Code Compliance. Initial violation for not having a certificate of use was found April 25th of 2022. During my final reinspection on February 17th, they still were not in compliance.
Based on the unrebutted testimony of the city's code enforcement officer and the evidence presented reflecting that the property has been out of compliance, this was not previously adjudicated, unlike the prior one, correct? This is a new one?
Yes, this is a new one.
Okay. All right. So because it is a new one, I'm not ratifying anything. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation still exists, that proper notice has been given, I find in favor of the city, enter adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. I didn't hear this one when I heard the prior one. I didn't hear them together.
No.
Okay. All right.
Item number 34 and 35. Mia Housing for LLC. Case number for item number 34 is CEFOB 2022-00312. And item number 35, case number is CEZCU 2022-00544. And the officer is Samara Petit.
Good afternoon. Officer Petit with City of North Miami Code Compliance. On April 28th, Mia Housing for LLC did not have a business tax receipt or a certificate of use. And on my final reinspection of February 17th, a business tax receipt nor a certificate of use was obtained.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set an abatement date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 36, 151 at Biscayne. Case number CEZCU 2022-00468.
They choose to skip over 35?
No, it was called with 34 because they go hand in hand.
All right, so we did 34, and I haven't done 35 yet. That's a certificate of use. That's a separate violation, right?
Yes, that's for Mia Housing for LLC.
Yeah, right. All right. Did I rule on that or no?
I assume you ruled on it from 34,
right, so,
but I can
so
call
the
it
same.
interrogatory if you like.
My rulings are the same both on 34 and 35.
No problem. Item number 36, 151 at Biscayne. Case number is CEZCU 2022-00468. And the officer is Samara Petit.
Good afternoon. Officer Petit with City of North Miami Code Compliance. On April 25th of 2022, a violation was opened for 151 at Biscayne for not having a certificate of use. Upon my final reinspection of February 17th, they were still not in compliance.
Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the violation still exists, proper notice has been given, I find in favor of the city and enter an adjudication setting an abatement date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 37, Oz and BF LLC. Case number CEZPU 2022-00149, and the officer is Gennaro Murillo.
Good afternoon, Officer Murillo for the City of Miami Code Compliance. On November 19, 2022, a violation was opened at the property at the address of 840 Northeast 130th Street. To please remove the construction trailer on the vacant lot until project is ready to start. In December 1st, 2022, compliance was not met. A notice to appear was posted on February 8, 2023. A notice to appear was mailed on February 9, 2023 as my final reinspection at February 18th. The trailer remains on the vacant lot.
And there's no ongoing construction?
No, sir.
So we have one lot that's vacant. That's where the trailer is. And then there's another lot owned by the same owner?
The trailer is inside the lot, which is, they haven't started.
So it's all one property?
Yes, sir.
And the trailer is there, but there's no construction going on. Do they have a construction permit?
So I'm sorry, Gennaro. If I may, Magistrate, they actually received zoning approval. Approval from Mayor and Council to develop years ago. There was an application and permits were submitted. They kind of just sat dormant for quite some time. We've received, several complaints about this trailer. At one point, they were given an early start to put the trailer there, provided, with the expectation that they were going to move forward with the construction and with the development. I know when this case was opened, we were in contact with a couple people. I believe the building official also was in contact with them. The permits were kind of at the end of their lifespan in terms of just getting ready to expire. They had been sitting for quite some time. I'm not sure if it appears as though, we have the case here today, so I'm guessing that they never come to renew, or there hadn't been any recent activity based on any of the contacts that were made. Mark, I guess if you I just want to double check though, because this was.
Yeah. What's the status of the permit?
So they have a permit application that goes back with 2018. And recently I've been in contact with the owner and also another representative of the owner, and trying to encourage them, hey, you're almost there, please, submit, corrections to try to get this permit. But it hasn't been a push in, I'll say, in recent 2 or 3 weeks. So I don't know what they are planning, but I'm trying to.
Well, if it's a matter of waiting 2 or 3 weeks to start construction, I'd hate to cite him, but if the trailer is just sitting there as a sore thumb and there's absolutely no activity ongoing, they're going to have to remove it.
Well, also, Mr. Magistrate, wanted to add, in terms of these are, I've been trying to encourage them to provide some corrections because the county has not officially approved them. So, I talked to Atlas with the owner. So in recent weeks, I haven't seen any movement to try to comply to even try to issue the permit. So I really don't know what to say. But
well, so have the permits expired and a new permit has been asked for? Is that what happened?
Well, the permit. We have completed some reviews on it. So I've been working with the developer to kind of see a way to keep it active, but. In terms of the last push, I haven't seen any of that from the developer recently in terms of trying to secure this permit. So
all right. So based on the unrebutted testimony of the city's code compliance officer, the photographs of the trailer and the evidence presented depicting that the cited violation still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
And Magistrate, that concludes all the items on the agenda for today.
Wonderful. So
major deadline.
Also, Special Magistrate and Crystal, that case, the last one, so we came to a resolution that it could be closed, and I sent the email to the attorney. That's item number 39.
That's fine. We can take care of that based on internally.
Okay.
Did we hear number 39?
We did.
Oh yeah, we did hear. That was the first case we heard.
Correct. Correct.
Right. Yeah.
He already dismissed it. So
I dismissed the case anyway.
Okay. Okay.
Yeah.
All right. Thank you, Magistrate.
Okay. Thank you. You all have a great week, great weekend.
Likewise.
See you next time.
Likewise. Thank you. Bye-bye.
Thank you.